on. It's like I tell everybody else. So if you're in here and you leave, you're not coming back. So just know that if you exit, the door's shut, because we're not going to have people in and out when people are trying to do their closing argument, okay? It's very important for them to not lose focus on their work. So if anybody needs the restroom, do it right now, because they're not quite here yet. Mark, you make sure the bailiffs all understand, if someone leaves, they're out. The other thing is, well, your phones are off, because that's disturbing if something all of a sudden starts ringing. Phones off, OFF.
And Angelina Gabrielle of the Kenosha District Attorney's Office.
Martice Fuller appears in person with Jillian Scheidegger and Carl Johnson.
Yesterday we stayed after off the record to go over the instructions at that time. So thus far, we'll pull specifics out after I go through the whole list of instructions, and you can make your record about your objections to any of the instructions. So 100 opening instruction, 110, 1 defendant, 3 counts. The information was approved. The substantive instructions were approved. 140, burden of proof and presumption of innocence. 145, information not evidence. 103, evidence defined. 170, circumstantial evidence that was requested by the state. Circumstantial evidence, flight, escape, and concealment, that was requested also. Motive, 175, was requested by the state. Statements of defendant, which is 180. 275, cautionary instruction, evidence of other conduct. There are 2 of those. One that was drafted by the defense, which is regarding the solicitation of communication with jurors, and it was approved by the state, agreed to by the state, and approved by the court. And then there's the second one, the cautionary instruction, evidence of other conduct. Mr. Johnson, you can make your record.
Your
You
Honor,
take your mask off.
specifically, we object to the portion of the instruction that talks about identity. We don't think that that is appropriate here, that there is... The instruction talks about that the prior conduct was so similar to the offense charge that it tends to identify the defendant. We don't think that the prior conduct that the state is introducing is so similar that it would tend to identify the defendant. It's not so unique or so similar, and so we don't think that that portion of the instruction should be read.
Mr. Gravely, or Ms. Gabrielle.
Your Honor, the state does believe that that language should remain in the instruction. The state's motion for other acts, which was admitted, was argued that all these other acts, step by step, lead us to the identity of the person who killed Kaylee Juga, and that the similarity in the acts is the similarity among the domestic violence acts, that this is a pattern of a domestic violence relationship throughout the course of both their time together and their time apart. And so this does directly travel to the identity of who murdered her.
And the court ruled, is ruling, as I did last night, that it is going to stay as it has been drafted by the court. Then we go to 162, agreed facts, and the request by both parties was that I not read the agreed facts in the criminal complaint of the pending jury issue, and not read the agreed facts or the stipulation on admissibility and chain of custody on the various pieces of evidence and the films. We'll get to a question of whether or not they can have those agreed facts and stipulations if they ask for them, but we'll talk about that later. Remarks of counsel is 157, 155 exhibits, 148 objections of counsel, 147 improper questions, 190 weight of evidence, 195 jurors' knowledge, 300 credibility without the paragraph on the defendant testifying because he did not. 315, defendant elects not to testify, was requested by the defense, correct, Mr. Johnson or Ms. Scheidegger?
That's correct.
Okay. 141, identification. 200, expert opinion testimony general. Expert opinion hypothetical, which is 205. And 201, opinion of non-expert witness. And we included in there Detective Kennedy, allowed to give an opinion on relative height and speed of a runner, and Ms. Schwensen gave an opinion on issues of domestic violence. 325, impeachment of witness, prior convictions, and there were 2 witnesses that had prior convictions. Closing arguments is 160. Then 460, closing instruction. The verdicts we worked on last night, and they were approved, and then unanimous verdict. Any objection to, other than those stated on the record thus far, any objection, Mr. Gravely?
No, Your Honor.
Ms. Gabrielle, sorry.
That's okay.
And any objection, Mr. Johnson?
No objection. I know we did, though, talk about on the verdicts that we just needed to change the date in the second question of the verdicts.
I did.
I assume that was done.
I did.
Okay, thank
I
you.
used that whiteout thing and wrote with my pen.
Okay.
Okay, everything else all set? Everybody all set? The exhibits are down here, Mr. Johnson, Ms. Scheidegger, if you need those. And I think we're ready to go.
Your Honor, could we have just a minute, please, before the jury comes in?
Say that again?
Could we have a minute before the jury comes in?
Okay, Mark, to put the halt, okay. Yes, we can.
So I wanted to put on the record a clarification. We've discussed this with with the attorneys for Martice Fuller yesterday. The video that showed a bike rider that was played yesterday, during cross-examination, Attorney Johnson had Detective Kennedy go to a point that was 54 minutes into the first segment of video. To some, that may have given the impression that at 2:54 p.m., this person in gray with a backpack was riding out of the Horizons neighborhood. Turns out that, in fact, it's because of the way it was captured on the video or transferred from the video, and depending on what player you use to show the video, it gives this impression. If you play it on the player that I used when I watched it, in which Detective Kennedy, the timestamp actually stays on the screen. And at 2:54 p.m., no one rides past that Nest doorbell. So I wanted to put that on the record. We talked to Attorney Johnson about this. He is aware of it. He has indicated he's not going to argue that in closing argument, but for purposes of the record, we wanted this to be clear.
And just so that we're as clear as we can be here, that we have reviewed that entire video from that afternoon. There's only one time that bicyclist passes at that place, and that is that time at 3:03 p.m. or right around between 3:03 and 3:04 p.m. So I don't think counsel disputes that, but we don't want there to be a situation where, for appellate court purposes, if the defense, having had that in evidence, fails to argue it, that they would in any way be ineffective, because all parties, I believe, are aware that this has to do with how it's spliced and how it, if you play a video, depending on what the player is, it would indicate a different time, because it's the player that then is dependent. It's not.
You're talking about the player counting, the counting
Right.
mechanism of the
Right.
player, not
Exactly.
time.
Not the
Correct.
time.
Correct. So I believe counsel, I believe that defense counsels understand it. We just simply want the record to be clear, because defense counsels indicated they do not intend to argue that, because I
Okay,
believe that they know.
and would the jury be under an impression that it was 2:54 and not 3:03?
Well,
Did we talk about that time, or did we say?
I believe counsel was careful. He said, based on the timer here, is that at the 54-minute mark? So I don't believe that counsel ever said it was 2:54. But I do think a juror might reach that conclusion. I intend to indicate in my argument that the only evidence in this case is that the detective reviewed this. There was only one time that this bicyclist went through, and that was at 3:03. And to argue that that any playing that occurred in cross-examination was simply using exactly the same video, but using it through a different player.
A different counter, call it a
Yep.
counter, because
Okay.
otherwise,
Okay.
Call it a counter, because everybody knows
All
about
right,
count to
so
this.
I intend to argue that, just so the jury is clear, and again.
Okay, so you'll clear it up there.
I believe
Mr. Johnson, you agree with that statement by the state?
Not entirely, I don't.
Okay.
So I know the state is indicating that it was played through a different player. I don't believe there's any testimony about it being played through a different player. We played the videos, and I had it queued up to 54:37. It shows what it shows at 54:37. I think I can remind the jury and tell the jury that what they saw was something at 54:37 on that first clip. I understand the state is saying there's this issue with the player, et cetera. But if that's not testified to, I don't know how the state gets to argue that. If the state wants to come up with some other way to make the point that they want to make, I think they're certainly able to do that, but I don't think that they can give an explanation that's not been given, or that's not, that Detective Kennedy did not testify to and say, and sort of say it's this issue with this player, et cetera, if nobody's testified to that.
Well, they could call a rebuttal witness this morning to do that, or it could be stipulated that it was the time, it was the counter on the device, not the time set.
So I
mean, I don't know if you can stipulate to that.
there's not a timestamp on the video. I certainly agree to that. There's not a timestamp. But what I'm saying is that the evidence that we presented is that Detective Kennedy testifies and says at approximately 2 o'clock, this person goes one way on the video. We said, cue it up to this time. It shows a person going a different way on the video. I think I can point that out to the jury that that's what they saw yesterday. I'm not going to say it's 2:54 because I can't say that it's 2:54. There's not a timestamp or counter on that. But I can say at 54 minutes into that video, this is what's on it.
Well, when you play that same video using the other player, the other mechanism for playing that video, the time is on the screen. And it does. At 2:54 p.m., no one rides by on a bike. They ride by at 2 and at 3:03 p.m.
Yeah, frankly, we are providing in the district attorney's office an ability to play these. So, and then we're doing that simply out of convenience for the parties.
Defense attorney.
What?
We're not providing the DA's office.
The DA's office has provided Mr. Stute and the equipment, so out of courtesy for the defense counsel in this case, private defense counsel or appointed
Right.
defense counsel to do this. So we are providing the machinery. We should not have a situation where the jury is exposed to what are absolutely false assumptions from the argument that's just been described, out of the courtesy of us providing these players in these circumstances. So, counsel had no obligation to tell us, listen, here's the snippet I'm going to play, which is a snippet based on that other player, that other counter. He had no obligation to tell us that. But again, that would not have been able to have been accomplished without the courtesy of us providing the staffing to do that. So we're simply suggesting some false information should not be provided to the jury because of us allowing that to have occurred.
How would you like to,
Well, I thought yesterday that counsel was indicating that they also knew that there is no bicyclist going through there other than at 3:03 p.m. So I don't know if counsel's now disputing that, but that was what I intended to say. I intended to say
no, he said he's not going to argue that that's a timestamp on it. He said, but he's going to say at 2 hours and 54 minutes into this tape, apparently.
I mean, if there is not a situation where we have a stipulation that that the bicyclist that was shown on video during the cross-examination is the same footage that was previously testified to have occurred at between 3:03 and 3:04 p.m., then presumably we need to somehow make a record of that. So whether we need to somehow supplement the testimony or in some fashion do that. I mean,
How would you like to do it?
For myself, I mean, my frustration is it's apparent. It's exactly the same video.
It's apparent to all of you because you're familiar with these pieces
Right.
of evidence. Those tapes, I can tell you for people who saw them for the first time, nothing's apparent. It was difficult to even read, the date from
Sure.
this distance. So do you four want to step into the hall and figure out a way to do it? Otherwise, we can have rebuttal.
That's what he wants or needs.
Yeah, sure. Yeah, we can go out,
Yeah.
we can go out and see.
Yeah, okay. It's been smooth so far. We're still in the jury room, right? Yes. Okay. Have you noticed since COVID, you don't have a cold? You haven't had a cold in a year?
Because everybody's washing their hands using sanitizer.
And not breathing their cold germs. Yeah, it's been great.
Obviously, the flu is
Minuscule. Yeah. Now, Miss McNeil got mono. And she said, I have no idea. I don't go anyplace. She said, I can't figure out how I would get mono. I go nowhere. I wear a mask. I wash my hands. I think she has a dog. Maybe the dog gave it to her. I don't know. Anyone have second thoughts on the restroom that can? It's an opportune time. There should probably be more over on this side. Those people in the front row have to crane their neck. Oh, boy. Okay, we're back on the record.
We are, Judge. We've had an opportunity to talk briefly. I think we have a general understanding of the same issues, but we have a dispute about how the parties would be permitted to argue this based on the current evidence. So we are asking the court to allow us to put on brief rebuttal to the cross-examination. Having had an opportunity, and essentially what happened was after the cross, we did not understand the technology sufficiently to ask appropriate cross. Now we believe we do understand that technology, so we're going to ask that we be able to supplement our redirect to be able to explain briefly through the detective to the jury what they saw when counsel pointed a video clip out to them.
Okay, and you need Mr. Stute out here, right?
We would.
And Your Honor, we're going to object to that. The case has been the case for a long time. If I understand the state may have wanted to have presented it in a different way, they did not. And so I don't think that they get an opportunity now at this point to sort of, now that they may have a regret about how that was presented, to now go back and fix it. I don't think they're allowed that opportunity, and we would object to it.
The court's going to grant the request. I believe that the importance of a jury trial is a full and fair display of the evidence to the jury. I think it would be a misleading impression if they were to think it was at 2:54 instead of at 3:03 or 4 or 6. And I think I can see that they could be easily misunderstand that piece of evidence. So the court is going to allow the information to be brought on. So bring us the jury, and Mark, they need their notebooks. So bring us the jury and get the notebooks out, and when they get in here, I'll have you call Mr. Detective Kennedy.
Brian, come in and help.
Mr. Gravely, any rebuttal witnesses? Oh, Miss Gabrielle, any rebuttal witnesses?
We're just going to continue our redirect, would be essentially what we're up to.
Oh, okay, I'm sorry. Detective Kinnessy? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Thank you.
Detective Kennedy, on Exhibit 75, which is the video of the person on the bicycle riding past the Nest doorbell camera. Do you recall that?
Yes,
Did you review that video in its entirety?
yes, I did.
Starting from what time to what time?
It would have been 2 p.m. to 4 p.m., I believe, is when we captured the video.
And when you say 2 p.m., you're talking actual clock time, correct?
Correct.
Not timer time on the player that shows the video as it plays.
That's correct, yes.
And when you reviewed that video using the clock time, when did you observe a bicyclist in a gray sweatshirt with a black or dark colored backpack riding by that Nest doorbell camera?
They were riding east at approximately 3:03 p.m.
And did you see the bicyclist riding west at any time?
Yes, that was shortly after 2 o'clock p.m.
Now, Mr. Johnson had you look at a clip of video 54, at the 54 marker on the counter at the bottom of the screen. You recall that yesterday?
I do, yes.
And we saw a bicyclist riding by going east, correct?
Yes.
What time was that?
The true time on that was 3:03 p.m.
And so no one was riding a bicycle past that doorbell camera in a gray sweatshirt and a dark colored backpack at 2:54 p.m., correct?
That is correct. No one was riding past at 2:54 p.m.
This says 2 to 3.
So Detective Kennedy, this is Exhibit 65 on the screen, and it says 2 to 3 p.m., correct?
Yes.
So I would ask that we play at 2 p.m. Yes, I see that. Mr. Stute, this says 2:08 p.m. Pardon me? No, I don't know what this is. Mr. Stute, could you stop that, please?
Why are you showing the difference?
I don't know.
I told people a long time ago, turn off the phones. Off. Off.
Okay, my apologies.
Okay, continue.
Okay, Mr. Stu, could you please advance the video to the 2:54 PM? Oh.
Okay, so now we ready?
Yes, I apologize.
Okay, the records reflect we're at 2:53.
May 9th, 2019. So Detective Kennedy, 2:53 to 2:54 PM, does any bicyclist cross the path of this video camera?
No, no one does.
Then I would ask now we advance to 3:03 PM. Thank you. Detective Kennedy, at 3:03, approximately 15, did we see a bicyclist in a gray sweatshirt with a dark backpack, white shoes, and jeans ride by?
Yes, we did.
I don't have anything further.
Mr. Johnson? Turn on your mic, okay?
So I want to go back to yesterday. So yesterday, video was played from the Nest camera from 109 19 69th Street, right?
Yes.
Which is the same home that the video we just saw is from, correct?
Correct.
The video that was played yesterday didn't look it's not the same as how we viewed it yesterday, right?
It's the same footage. I believe it's a different player.
So yesterday, we watched it in a way that did not have a timestamp on it, correct?
Correct. There was a counter.
And when you say a counter, you're talking about within the media player had its own counter.
However, the video was spliced. That's when the counter was from. So if you're asking that, that's my understanding of it. Whether it's contained within the media player, that might be true, but I'm not a technical guy. I just know that it wasn't true time, it was a counter.
Right, there's not something that says right now the video that we watched yesterday did not have a counter that said the time is 2:01 p.m. or something like that, right?
Correct, yes.
Exhibit 75 is the disc that contains the video that we just watched, right?
I believe so. I'm not sure the exhibit number, but I mean, if you're telling me that, that's probably true.
That's what I think it is.
Okay, I would agree with that.
And you've reviewed the disc that has the footage from 109 19 69th Street, right?
That is correct.
There are 2 files in that disc, right?
Yes, this broken up in 4 hours, I believe, or 2 hours, I'm sorry, from 2 to 4.
So 2 hours, 2 files, right?
I believe so, yes.
The first file is labeled 2 p.m. to 3 p.m.
Yes,
The second file is labeled 3 p.m. to 4 p.m.
correct.
Yesterday, when you testified, you were shown on the other player the 2 p.m. to 3 p.m. clip, right?
Correct.
And at some point in that video, there is someone on a bicycle going westbound past the house, right?
Yes, so we observed the footage that we just saw of the same person riding eastbound through the house. The correct time on that would have been 3:03. Yes, I'm sorry. What we saw yesterday was the same footage that we just saw today. The correct time, true time would have been 3:03. I believe it's 15 or 3:03:18.
Now, when the person on the bicycle goes westbound, that's not 3:03, that's earlier, right?
Correct.
Yesterday, you said it was approximately 2 o'clock that occurred.
Correct.
And then on cross-examination, I showed you that same video that we saw yesterday of the 2 p.m. to 3 p.m., right?
Correct.
And asked that it be advanced to 54 minutes and 37 seconds on the counter for the player.
Yes.
And at that time, it shows an individual on a bike going eastbound, right?
Correct. That is the same footage that we just saw. The correct time on that, again, is 3:03:15. It's not 2:54:30. It's 50, however that video is spliced, it's 54 minutes into that. The true time at that is 3:03 p.m. Just the footage we just saw, it's the same footage.
So even though the file says 2 p.m. to 3 p.m., I guess what you're saying is that's not correct, right?
I don't know how that specific file was spliced or played on the viewer. What I know is the correct time was 3:03 PM. So I believe that's a counter. I don't know what time that starts on that specific file. I do know correct time, we see that individual leaving at 3:03 PM.
Well, and we saw today that if you do the file on a different player, it looks, the way that time is counted is different, right? There's a timestamp on the one we just saw, right?
There's a timestamp on the one that we just saw, that was 3:03 PM, yes.
There's not a timestamp on the one that we saw yesterday.
Correct, there was a counter.
That's all I have. Thank you.
Okay, thank you. Anything else, Ms. Gabrielle?
Just to clarify, Detective Kennedy, what we saw yesterday and what we saw today is the same disc and the same recording, correct?
Correct, yes.
The difference is when Mr. Stute double-clicked to open it yesterday, it opened in one player, and when he clicked today, it opened in a different player that showed the time, the actual clock time.
Yes, that's correct.
Nothing further.
No follow-up.
Okay, thank you.
Thank you.
Right, just hang on. Anything further, Ms. Gabrielle,
No, Your Honor.
Mr. Johnson, or Ms. Scheidegger?
I don't have anything further than what's been said.
Okay, that concludes the testimony. Okay, so collect the notebooks. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about the law, what the law is, or what it ought to be. You must base your verdict on the law that I give to you in these instructions. Apply that law to the facts in the case, which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and your best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of the facts solely as you view this evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The information in this case charges in count 1 that Martice Fuller, on or about Thursday, May 9th, 2019, in the city of Kenosha, Kenosha County, Wisconsin, did cause the death of Kaylee Juga, date of birth 8/28/03, with intent to kill that person, contrary to Section 940.01, and further invoking the provisions of Section 939 Wisconsin statutes. The defendant committed this offense while using a dangerous weapon. To that offense, Mr. Fuller has entered a plea of not guilty, which means that the state must prove every element of that offense beyond a reasonable doubt. First-degree intentional homicide is defined in 940.01 of the Criminal Code of Wisconsin. is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence, which satisfies you beyond a reasonable doubt, that the following two elements were present. One, the defendant caused the death of Kaylee Juga. Cause means that the defendant's act was a substantial factor in producing the death. And two, the defendant acted with the intent to kill Kaylee Juga. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of the defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Kaylee Juga with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The information alleges not only that the defendant committed the crime of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer the question yes, you must be satisfied, beyond a reasonable doubt, that the defendant committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. Count 2 in the information alleges that Martice Fuller, on or about Thursday, May 9th, 2019, in the city of Kenosha, Kenosha County, Wisconsin, attempted to cause the death of Stephanie A. Juga with intent to kill that person, contrary to Section 940.01. And further invoking the provision of 939, the defendant committed this offense while using a dangerous weapon. To that allegation, Mr. Fuller has entered a plea of not guilty, which means that the state must prove every element of this offense beyond a reasonable doubt. The crime of attempted first-degree intentional homicide, as defined in 939.32 and 940.01 of the Criminal Code of Wisconsin, is committed by one who, with intent to commit first-degree intentional homicide, does acts toward the commission of that crime, which demonstrate unequivocally, under all of the circumstances, that he or she had formed the intent and would commit the crime except for the intervention of another person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1, the defendant intended to kill Stephanie Juga. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. And 2, the defendant did acts toward the commission of the crime of first-degree intentional homicide, which demonstrate unequivocally under all of the circumstances that the defendant intended to kill and would have killed Stephanie Juga except for the intervention of another person or some other extraneous factor. Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone but the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside the defendant's control. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances, in this case, bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant intended to kill Stephanie Juga and that the defendant's acts demonstrated unequivocally that the defendant intended to kill and would have killed Stephanie Juga, except for the intervention of another person or some other extraneous factor, you should find the defendant guilty of attempted first-degree intentional homicide. If you're not so satisfied, you must find the defendant not guilty. The information alleges not only that the defendant committed the crime of attempted first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. If you find the defendant guilty, you must answer the following question. Did the defendant commit the crime of attempted first-degree intentional homicide while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime while using a dangerous weapon. If you're not so satisfied, you must answer the question no. The third count in the information alleges that Martice Fuller, on or about Thursday, May 9th, 2019, in the city of Kenosha, Kenosha County, Wisconsin, did intentionally enter a dwelling without the consent of the person in lawful possession of the place, and with intent to commit a felony while armed with a dangerous weapon, contrary to Section 943.10. To that allegation, Mr. Fuller has entered a plea of not guilty, which means that the state must prove every element of that offense beyond a reasonable doubt. Burglary, as defined in 943.10 of the Criminal Code of Wisconsin, is committed by one who intentionally enters a dwelling without the consent of the person in lawful possession and with intent to commit a felony therein. Before you may find the defendant guilty of this offense, the state must prove by evidence, which satisfies you beyond a reasonable doubt, that the following four elements were present. 1, the defendant intentionally entered a dwelling. 2, the defendant entered the dwelling without the consent of the person in lawful possession. 3, the defendant knew that the entry was without consent. And 4, the defendant entered the dwelling with intent to commit the felony of first-degree intentional homicide. That is, that the defendant intended to commit first-degree intentional homicide at the time the defendant entered the dwelling. The intent to commit a felony must be formed before entry is made. The intent to commit first-degree intentional homicide, which is an essential element of burglary, is no more or less than the mental purpose to commit first-degree intentional homicide formed at any time before the entry, which continued to exist at the time of the entry. You cannot look into the person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The information alleges not only that the defendant committed the crime of burglary, but also that the defendant committed that crime while armed with a dangerous weapon. If you find the defendant guilty, you must answer the following question, yes or no. Did the defendant commit the crime of burglary while armed with a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon that acts by force of gunpowder. Armed means that at the time of entry, the weapon must have been either on the defendant's person or within the defendant's reach. In addition, the defendant must have been aware of the presence of the weapon. If you are satisfied beyond a reasonable doubt that the defendant committed the crime of burglary while armed with a dangerous weapon, you should answer the question yes. If you're not so satisfied, you must answer the question no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. Well, it's your duty to give the defendant the benefit of every reasonable doubt. You're not to search for doubt, you're to search for the truth. And information, I just read to you, is nothing more than a written, formal accusation against a defendant charging the commission of one or more criminal acts. You're not to consider it as evidence against the defendant in any way. It doesn't raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes into the jury room. And third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed, and also after he was charged with these offenses. Whether the evidence shows us consciousness of guilt, and whether consciousness of guilt shows actual guilt, are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, The state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Evidence has been presented relating to the defendant's conduct after the defendant was accused of a crime. Specifically, evidence that the defendant solicited others to communicate with jurors in February of 2020. Whether this evidence shows a consciousness of guilt, and whether consciousness of guilt shows actual guilt, are matters exclusively for you to decide. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offenses charged. Evidence that the defendant solicited others to communicate with jurors does not relieve the state of its burden to prove each and every element of the crimes charged beyond a reasonable doubt. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant previously engaged in threatening and violent behavior to Kaylee Juga and made efforts to get a gun, posed with a gun, and tried to enlist another to kill Kaylee Juga for or with him. If you find that this conduct did occur, you should consider it only on the issue of motive, intent, preparation or plan, identity, and context or background. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. The evidence was received on the issues of motive, that is, whether the defendant has a reason to desire the result of the offenses charged. Intent, that is, whether the defendant acted with the state of mind that is required for the offense charged. Preparation or plan, that is, whether the other conduct of the defendant was part of a design or scheme that led to the commission of the offense charged. Identity, that is, whether the prior conduct of the defendant is so similar to the offense charged that it tends to identify the defendant as the one who committed the offense charged. Context or background, that is, to provide a more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purpose I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person or for that reason is guilty of the offenses charged. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept those facts as conclusively proved. Remarks of the attorneys are not evidence. If the remarks suggest certain facts not in evidence, disregard that suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit is evidence whether or not it goes into the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about that evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question suggested certain information might be true, ignore that suggestion and do not consider it as evidence. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and your experiences in the affairs of life. It is the duty of the jury to scrutinize and weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight that you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight that you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and your experience. In everyday life, you determine for yourselves the reliability of things that people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by the witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider the witness's opportunity for observation, how long the observation lasted, how close the witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear the events and any other circumstances of the observation. You should also consider the period of time which elapsed between the witness's observation and the identification of the defendant, and any intervening events which may be affected or influence the identification. In evaluating the identification evidence, you are to consider these factors which might affect human perception and memory, and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you're not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. That's called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it was based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Ordinarily, a witness may testify only about facts. However, in this case, Detective Kinnessy was allowed to give an opinion as to relative height and speed of a runner, and Ms. Schwensen gave an opinion on issues of domestic violence. In determining the weight that you give to these opinions, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you're not bound by the opinion of any witness. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions that the court has given you. So now we'll do closing arguments. The state starts. Mr. Johnson, I believe, will follow, and then the state gets rebuttal. So we'll start with that. Mr. Gravely.
Thank you, Your Honor. Your Honor, members, counsel, members of the jury, thank you for this opportunity, and thank you so much for your patience in this case, allowing us to be here today and finally argue our take on the facts and circumstances of what you've heard over the last several days. I want to start with a task that I think we're all inadequate for, and that is I think we have to begin by trying to talk about the unspeakable loss here of young Kaylee Juga. In this case, we know from her friend Jennifer that Kaylee was outgoing, that she was brave, that she was gentle, that she was smart. And we know from hearing and talking about her through others' eyes that at the age we lost her, the world was really waiting for her. We know because we saw Jennifer DeZoma, she'd be a senior. In this chaotic school year that has just happened, she would have suffered through that with all others. She'd be about to graduate. She'd be in that spectacular set of moments where she thinks about jobs and colleges. It was all just about to happen. She was at the very start of those beginning adult chapters of your life. At 15, where you think you know everything and don't know a thing. Where adulthood looks so clear and yet it is so confusing. She was there. And like the early part of so many of our life stories, she met somebody, right? She met a boy. And sometimes that's the brilliant beginning of life stories. For her, it was the end. For Kaylee Juga, that was the end. Because this defendant took her love and affection, took her bravery and gentleness, and he deliberately and he violently made it so she could never move on. She missed that opportunity, members of the jury, that is so profound, that second relationship in your life. That relationship where you understand, okay, the world has choices, and it's not all or nothing, and the world has all sorts of shades of love and life experience. She never got it, because it was all he could do to make sure she would never, ever get there. That second chapter and story was going to be denied her. So I'm going to talk about the evidence in some detail. And you guys have heard it, so you will not hear new information. You'll hear the information we've talked about for several days. And I'm going to ask you to think about it with a few different sort of ways to organize it, ways to process what I will be talking about and you have heard. I'm going to ask you to think about this defendant and make some judgments about whether he is a person, one of those people who says, no rules really apply to me. Whether all that you hear and see show he is a person who says, I will not be defined by any of these rules. I ask you also to think about whether he is a person who has a profound ability and degree within him to manipulate others to his purposes. Is he that individual who again and again will use people? Think about all the people who he potentially got in very, very serious circumstances by asking them innocently, without giving them anything but the most selective information, for their sympathy and their kindness, and in taking advantage of that, he achieved her death. And then, we have talked from voir dire through witnesses about domestic violence. And I ask you as jurors to think about this case, though the individuals here are young, within that prism, within that definition of the things we know about domestic violence. Because I'm going to submit to you in this case that the time together between Kaylee Juga and this defendant was defined by domestic violence. And the time apart was the tragic, horrific end of the worst of domestic violence relationships, and that was her violent murder. So as I talk about this case, I'm going to talk about domestic violence and how that defines what happens. I'm going to talk about how a person, the defendant, said, no rule will ever stop me from my obsessions, from my absolute insistence that I have control in this situation. And that no one was someone he didn't feel he could manipulate to his purposes. That end purpose being the death of Kaylee Juga. Because Kaylee Juga was controlled by this defendant, and then he was hurt by this defendant. Kaylee Juga was stalked by this defendant, and then Kaylee Juga was murdered by this defendant. And the Juga family here today is left broken. They're left broken in a house where you can't take a shower alone without that horrific, nightmarish reminder. And where the garage is never, ever going to be safe. They are broken. So, this domestic violence relationship has its beginnings in 2018, and the defendant was again and again welcomed into the Juga home. He's there for movie nights. There's the kind of rules that parents have where you can't have the door closed, and one of you has to be on the floor, one of you on the bed. There are holidays spent together. They fed him numerous times. They spent numerous evenings with this defendant. Their generosity as a family caused him to know the rooms and the security cameras and the windows that allowed him the information that broke them. And of course there was teen love, But there was also controlling behavior. You heard Stephanie Juga say, you know, there came a point where there were just way too many calls. I couldn't be in the car with my daughter without her endlessly having calls from him. I had to actually tell him myself, hey, this is a time when she's with me, you need to cut it out. And he would blow it off, but this behavior continued. She would be in her room, and she would always have to have him on the video. They weren't even speaking, but he would always have to be monitoring her activities in her room. So the controlling behavior was even then going on. And by the sophomore year, as this relationship got to its second stage, second part, by sophomore year, you have her friends say, I witnessed in the comments an argument where I saw my friend Kaylee have her ear yanked by the defendant, yanked so she went to the ground. So not just a pull, not a joke, hard enough that a teenage girl cannot keep on her feet and goes all the way to the ground. Not controlled by a public place. Not worried about detection or being caught. None of those things matter because my control is all that I will be concerned about. I know no limits. My control will not be impacted by the fact I could be seen or disciplined. None of that matters. She will do what I want. And I will hurt her to make that happen. Now, you might say, okay, this is another teenager. You know, what if she has drama in her? What if she, you know, misinterpreted? What if just out of friendship she's, you know, said something that, you know, should we as a jury just adopt what one teenager says and believe it defines what I'm being asked to do today? But you don't have to worry about that, do you? Because you know on January 17th, 2019, less than 4 months before Kaylee Juga is murdered in her home, this defendant is not just witnessed by another teenager, he's witnessed by multiple teachers and an assistant principal. So let's talk about January 17th and whether we know this is a violent, disturbing domestic violence relationship where now, in retrospect, we can see how we got to that horrible day. January 17th, argument. Kaylee Juga, just trying to figure out some boundaries, trying to figure out as the victim in these things, what is it that I can do to keep myself safe or in some way take the pressure off me? She asks a teacher to intervene. Not easy for a teenager. She asks the teacher, separate us, please. The defendant will have none of that. You teachers, you don't control me. I'm in my control zone here. You teachers you don't impact me at all. You authority figures, you don't get to decide anything for me. The teacher tries to get him to leave, he won't. All he wants to do is move him to another location in the class. No, that won't be happening. He calls security. Still, knowing security is coming. Absolutely not. I'm in control here. Security are not going to stop me. This is my control zone. Security gets there. They're insistent. That doesn't work. Now, the school police officer has to be called. And now the vice principal is interested. Okay, I got 2 teachers in that room. This is a classroom with 2 teachers. I got security personnel, and they feel they need to bring a cop in. Something must be out of hand. January 17th. The 2 teachers, you heard Mr. Anglin, say, I and the other teacher physically tried to get between the defendant and Kaylee. This is an actual physical barrier of adult authority figures. Here is a wonderful snapshot to figure out if we have a defendant who is in any way under control on the issues that we worry about. What does he do? He shoves through teachers because he will be in control in the presence of security. And when he gets to Kaylee, with those teachers present, he is bending her hand. She is crying because he must have her phone. Not his phone, her phone. He has to have her phone. And so I will go through any number of teachers and I will harm her to make sure this is done. Because I am in control. The vice principal gets there. Her immediate instinct is to go to a person who clearly is a victim in this situation. The phone is not recovered until the security cop says there will be consequences, meaning the possibility of some crime. That's what happens when a cop tells you that, unless you give it back. And only then does he fling it. Only then. He's escorted out. School officials try to go different routes to keep people separate, and they accidentally end up in the same area. Here's what you were told by the assistant principal at Bradford. This is the person who supervises the deans. What she does all day is school discipline. So we're not talking about an amateur here. She says the two of them end up in the same hallway. There are still law enforcement, school security, a teacher who's coming to do a report, and the vice principal. I'm not sure you couldn't gather in short notice more authority figures in a school at any split second. When the defendant sees Kaylee again, with all those people who should have any rational, under control person understanding, okay, I was out of hand a second ago, I got to get myself together here. I got to be cooperative now because it's not acceptable or normal behavior to again lose it. In that hallway, no teenager tells you this, the assistant principal at Bradford tells you that not only did the police officer warn Martice Fuller, the defendant, don't touch her, don't have any contact with her, but the vice principal says she also told the defendant not to go at her, not to make any new contact with her. Is the defendant in any way under control? Or is his absolute requirement that he control Kaylee Juga so defining of him that he will defy everybody that I just mentioned? Well, we know the answer. Because he made it through those people and grabbed her backpack, having just been warned not to do that, and said, "You're going to do me that way." This is a young man at that time, this defendant, who has shown us, again, that he is willing and capable to be dangerous in front of witnesses, with consequences coming. None of that matters, as long as he gets to be in control. Just as that domestic violence mentality tells us is the absolute necessity and requirement of an individual who is an abuser in those situations. So again, he has to be physically separated. And the assistant principal, who does school discipline all day is really alarmed. When you alarm a person like Jill Swenson, you're saying something. You are somewhere high on the scales. She called it an extreme case. That's what she told you under oath and testimony. So then, now that incident in terms of the moment of it is over. And Jill Swenson, the assistant principal, is thinking, how can I give Kaylee some respite and still allow everybody to still, coexist here at my big high school? And one of the things that Kaylee told her, and this is another way control is asserted in a domestic violence relationship, right? She says, I would like to break up with the defendant. This is Kaylee telling Jill Swenson. But he tells me he will harm himself, and I don't want that to happen to him. So this threat that if you try to take away my control, if you break up with me, I will harm myself. Of course, that's another control mechanism, right? That's saying it will be on you. It's guilting somebody into staying in a relationship with you, another vehicle of control. And it helps define why Kaylee Juga has the impossible choices she has at each moment in this case before she dies. So one of the things that the assistant principal says is, you know what, I'm going to get these people, I'm going to change their classes, all right? I assume that's handbook of school discipline number 1, right? You got two people with a conflict, you switch their schedules. I assume that's number 1 in the playbook. It sent the defendant, who was, I believe, serving a suspension, into high volume. You heard the assistant principal, he called every office at the school looking for me. I mean, who does that when they want to talk to the assistant principal? Who won't just leave a message? Who feels they must call every office in a school where a school official says, here's what the guy was doing? It was so insistent, there were so many calls, that she, who was at a district meeting in another building, was called by her secretary or somebody working as doing the phones, saying, hey, would you call him? We can't take this anymore here at the building. So she actually leaves a meeting and calls the defendant back. This is a student, because he will not let anyone rest at Bradford because he's about to lose control. And no limits apply to him. Who would make more than one call and just wait and sit? If you had something to say to an assistant principal, who does this? And so she calls him, and what did she tell you about that phone call? He was trying to persuade her. She was telling him, no, this is going to happen. He would not stop. The assistant principal had to hang up on him. He knows no limits. No authority is going to stop him. And now, again, a glimpse of who we're dealing with. There is the meeting that his mother attends with him at Jill Swenson's office. And this is a meeting to talk about what Jill Swenson has come to, which is, hey, we're going to have an agreement that allows the defendant to continue his priorities, staying at school, playing football, as long as he does something very simple. He stays away from this person who Jill Swenson believed was in danger. And what did Jill Swenson, an experienced person who does this every day, what did she tell you? She told you that this was an extreme case of anger. She said, the defendant called me a liar when I reported to him what I myself had seen. I mean, they're talking about the interaction in the hallway. The defendant is going to tell the assistant dean, when she says, here's what I saw, you're lying. He put his finger in my face. The student put the head disciplinary officer at Bradford, he put his finger in her face. She said, based on that interaction, I personally was scared. He has frightened a person who does school discipline all day. The assistant principal is frightened about what anger he shows her sometime after January 17th about the rules or anybody making rules about him and Kaylee Juga. No limits, no control. So, you would think this abeyance agreement is the perfect test, right? Because we assume that the defendant has prioritized, I want to stay in school, I want to play football. So here is our ability to monitor whether he understands that there are rules that apply to him and whether he can follow them. And it only lasts a few weeks. It only, we know the answer to whether he feels any rules apply to him in regards to Kaylee Juga in just a few weeks. All he's supposed to do, evidently he's allowed to see her out of school, okay, because she is minimized for a variety of reasons, we assume, and he is minimized, and so he's being allowed. So it's just about the school day. And yet, what happens is, in late February, he corners her at a locker. He grabs her. This is after they have already broken up. It's evidently on video. The school people get a chance to see it. And showing he cannot be in compliance, the defendant is now out. Because they have to do what they can to protect Kaylee Juga. Because there's been another time where he showed the rules don't apply to him, and he will do physically whatever he needs to do to get control. And, Kaylee Juga agonized. You could tell that from Stephanie DeZoma and then from her mom's testimony about whether to tell the school about that incident. She agonized, and one of the things she discussed was, isn't this just going to make it matter? If I try to give him consequences or try to draw a line here, essentially the idea is, aren't I in any even more danger? And this is the nightmarish scenario for someone who is a victim in the midst of this type of situation, right? Because if they're going to try to get consequences, if they're going to call somebody on the things they think are dangerous, they have to worry that they'll ramp up the anger. And so they'll be in even more danger. And so, our general and our generic advice, if you and I heard somebody say this, we'd say, yeah, please go tell the authorities, right? But would we be expecting, or would we be preparing for those individuals who are so obsessed with control in a relationship that their ramped up anger will actually be potentially fatal? Because that is what we have with this defendant here today. That's the consequences of the ramped up anger. Because right after that happened, the conversation with the people who we have heard from in this case is, Kaylee ruined his life, that Martin Torres said that. Martin Torres said, this is a close friend of his for years. He said he wanted to kill her. Austin Hernandez, yes, he said he blamed her for things. He said that she was responsible and had ruined his life. And from there, from March 1st on, there's the contrast of both of these people's behaviors. Because the pattern of behavior is Kaylee Juga thinking of every strategy she can think of to try to get safe. And in contrast, the defendant spends the next 2 months preparing to hunt and kill Kaylee Juga. What did Kaylee do? Kaylee changed her work. She actually got a different job. It was a heartbreaking letter she sends to Martino's. I mean, for a girl of this age to have to say, thank you so much for my first work opportunity, I don't feel safe. She had the number blocked. This is an open place of business. She got them to agree to keep the doors locked so that customers would have to knock to get in. I mean, they had to change their way they do business to try to keep her safe. She would no longer go anywhere alone. Imagine a 15-year-old. Her life, she's now sentenced because of this ex-relationship, she can't go anywhere alone. She can't, and this is probably the one that I don't understand, but that someone of a different age would, she cannot go someplace with friends and let anybody post or acknowledge where they are. You can't do the selfie that shows the sign on, that you're at Great America, et cetera, et cetera. You can't have that life, is what she thought. She joked with people, probably because of the defense mechanism for a human being trying to live every day. She joked with her friends, he's going to kill me. She tried to make it something that could be funny so she could live every day. So she took those steps to try to still be a person living a life and be safe. During those same months, what is the defendant doing? The defendant is getting one guy to give him ammunition for a gun. He is asking someone else to take a picture of him proudly posed with the gun he has obtained. He sends that out to people. Here's my gun. When people see him, he shows them the gun. Would you like to hold it? He takes a bike from the Bowen's household and he stashes it at Ezra Stargell's house, which has the advantage of being a great staging point for your murder, because it is directly across the street from the subdivision. So you have a great staging point for whatever is going to come next. He's at Desiree's, where not once, not twice, but 3 times in either communications by media or in person, he says to her, I'm going to kill Kaylee, and he tries to recruit her to help. Desiree, who says he's in a dark jogging suit, the dark jogging suit that he has with him on May 6th, but somehow we can't find now. He's then at Alexis Fertney's. Alexis Fertney, who's perhaps the perfect person to manipulate. She's the type of person who, if you stay at her house a couple nights, she has crutches and she will still go buy you McDonald's for breakfast because you like pancakes. And so she'll still go do that. And heck, she'll give you a ride wherever you want to go. And in fact, if you blow her off in the mid-afternoon, if you make her come all the way across town to pick you up, and she's literally, almost pathetically, going from parking lot to parking lot thinking maybe he'll be here. And then she drives home. If you contact her again, guess what? She'll drive all the way across town to get you again. So you're with Alexis Fertney, and Lexi, trying to figure out how to stay safe and thinking Lexi Fertney is a friend of hers, is mad because he's at Lexi Fertney's. Here he is again, entangling himself with her life in a way that feels to her like, how am I ever going to get out from under this? And Lexi Fertney and the defendant talk about that when he wakes up in the morning on the 9th. Before noon on the 9th, he's back with Desiree saying, you need to do that to her. I'm so mad. And then the plan is hatched. Then it's the day that this is going to happen. Because he says, drop me at Ezra's. We know they leave at 12:40. We see that on video as they're walking out of the house. We know from 1:07 to 1:12, they're at Stein's. Okay, we know that that Alexi drops the defendant at Ezra's. Few minutes later, as she's doing her stuff, he says, pick me up in an hour. Which conveniently is at 2:40 p.m., which conveniently will be after he knows that that Kaylee and her mom will be home from school. They get home, remember, typically around 2:20, so it'd be a perfect time for him to be picked up again at Ezra's. He gets over to Ezra's, it's sometime around 2, just before 2. He says to Ezra, just before 2, or around then, I'm going to go to my grandma's. Ezra sees him leave on a bike. Ezra's looking out a window, sees him leave on a bike. Just after 2, just into the subdivision, so just literally across the street and a few houses on a bike, seconds after he's left on that bike, we see the defendant riding. We're going to talk about the clothes in a while. And he's headed towards the park. And if he goes on, it'll be towards Kaylee's house. At 2:20, Kaylee and Stephanie return home. And I think we know from the testimony that Kaylee's last good memories are music and dancing and teasing with her mom. And so if we have anything to smile about in this case, it's that those last moments had some joy. Lexi shows up right on time. She is the perfect person to manipulate. At 2:40, she's at Ezra's house, no sign of the defendant. She makes it basically back home before the defendant gets in touch with her, and now he wants to ride right away. And she says, listen, I got to switch cars. I'm driving my mom's car. I got to switch, so I got to get the rest of the way home. And he then begins to call other people for rides. Why? Because if you're over by Ezra's house, as we know from Cole Ballard, the sirens are going nonstop. It's clear that law enforcement who were called at 3:02 are all over the area now. And so this is an individual desperate. The defendant is desperate to be removed from this location. But the only person who will answer him is Lexi, right? So she drives back, she picks him up. It's sometime after that. At 2:56, 52, he's at the driveway of the Juga home. He's in all black, but with those same white shoes, he's in all black. It's more than a minute before you hear any shots. So when he walked in, did he try to get a feel for who was there? He knew the cars, but did he try to just make sure? Did he head up? Did he savor the moment? Did he have any moments of regret and then got up the courage, bolstered himself to do what would get him back in control? We don't know. We know a little more than a minute later, he shoots 7 times. We know that after just 3 minutes and a few seconds, he runs out. He runs out on foot the same direction he came, which is back towards that park, ultimately back towards that doorbell camera that sees him at 3:03, back in a different change of clothes, headed back towards Ezra Stargell's house on that same bike. And Stephanie Juga talks about how she's in her bathroom, which you saw from the diagrams is a couple of doors away from her daughter's room. Think about closed doors and a hair dry, hair care blowers going, those kind of things. But at some point, she hears the sound that gets through to a mother. Shots can be all sorts of things, guys. Shots can be anything from a firecracker to a car backfire to somebody slamming something in a neighbor's yard. But if you hear your daughter scream, that pierces the doors. Your daughter's scream is not something you have to sort in your brain and your brain subconsciously ignores. So probably after several shots or multiple shots, that scream pierces her. And she heads out and she hears more shots and one more scream. Now, Kaylee is shot 5 times. And you heard the medical examiner say if there had been a team of surgeons at this location, they could not have saved her. But I do want to talk for a moment about the circumstances of her wounds so that we're clear about questions of murder. You heard that and saw that there were gunpowder that had burned her arm. You also heard that Stephanie, one of her shots goes through an arm and then into her chest. And I want you to think about that moment when you would see or first realize that a person who you have been fearing for months has a gun and it's pointed at you. And I want you to consider whether just as Stephanie almost certainly got an arm up and had a bullet go through her arm and into her chest, whether the very beginnings of that same type of action would be what happened to Kaylee as well. Did Kaylee begin somehow to try to get her arm in the way so that her arm was closer to the gun and so took the gunpowder? But we know the bullets went into her chest. And I'd submit to you that it is logical for you to believe those chest bullets Probably almost all of them occur first. Why do I say that? Because there is one shot to the head. If you remember, on her head, there is also a black mark which appears to be gunpowder burn. So again, that gun is close enough to her head where it burns her skin. It's not just the shot, it's the burning of the gunpowder on her skin. The bullet through her head goes through. It's a through and through shot. There's an entry and an exit wound. And there is a bullet right where her body is, right where she lays, that goes into the floor. So I'd suggest to you the last shot in this case was the defendant. That shot is directly above, shooting Kaylee Juga on the ground and shooting her defenseless and shooting her such that the bullet can go through both parts of her head and into the floor. And I'd submit to you that when you think about the question of intent in this case, you stop there. I'd suggest your work is done when you consider that wound and how that is really the reasonable explanation for the powder burn, wound to her head, and bullet in the floorboard, meaning it would have to be shot down. And Stephanie gets there, and you heard the 911 tape. And so you know that if there was any consciousness left, when the officer gets there, he says he feels some sort of pulse. But if there's any consciousness left, you know the woman who brought Kaylee Juga into this world did everything she could to bring her back. You heard that. And it could not be done. Even a mother's love could not do it. Because the defendant had acted on his plan and he had done his work. So, in the end, this case finally comes down to what is reasonable. In the end, this case is really about what is all the evidence you have heard, and is there any possibility that this evidence could all be combined so that it would have to be faced at jury trial by some man who was innocent and falsely accused? Now let me be very clear here. The defense has no burden of proof whatsoever. So I do not mean to make an argument to you today that says they have to prove anything, because that is absolutely not the case. But I'd suggest to you that one of the ways you may look at the evidence is to say, okay, could an innocent person have all of these things happen to them that seem to indicate guilt? And I'd submit to you, in the end, when you consider them all, there's no way an innocent party, a person falsely accused, could have all these things happen. So I'm going to go through those with you, and then I'm going to conclude. So, first, on May 9th, Kaylee Juga is killed by someone at 3 p.m. Okay, now remember, this is a scenario where we're considering the defendant might be innocent and falsely accused. At 3 p.m., Kaylee Juga is killed at her home. Okay, and here's a horrible circumstance. If you're innocent, well, yeah, you know her, right? But, a lot of people knew her, so that doesn't say anything immediate. But her mom, Stephanie, is also shot. Okay? So if you're innocent, this is something that should immediately clear you. Because you know this family. You've been with this family many times over the last year. And so if you are innocent and falsely accused, the fact that Stephanie survived should be the greatest thing that ever happened. Because now you will be clear. But instead, here's the horrible circumstance. If you're innocent, Stephanie Juga on 911 is already saying, the person who shot me is the defendant. And not only that, she continues to say it and has said it here in the courtroom. And here's how horrible this is. Here's how unlucky you are if you are falsely accused. This is not a identity from a distance. This is not her having to check and see somebody who shot at them with a sniper rifle. This is someone who she saw face to face in her house and had a conversation with. So this is not a split second where you'd have no opportunity, it's at a distance, maybe I saw them, maybe not. This is an identification of someone who knows you where they had plenty of time and close proximity to make the identification. What a horrible set of circumstances if you're innocent. That Stephanie Juga would be that profoundly mistaken or would choose to frame you and what? Let the real killer go free? Let the person who really killed her daughter go free because she wants to frame you instead? Those are the kind of things you'd have to believe for this to be reasonable, for the defendant to be innocent and it to be reasonable. And now here's a horrible circumstance if you're innocent. You have a motive. You're broken up and you've been expressing anger about that for months with all sorts of people. So of the people that we could find who might have some ill will towards Stephanie, you're the top of the list. A horrible circumstance. It certainly would make you a suspect, and a horrible circumstance if you are completely innocent. Here's also a horrible circumstance if you're innocent. There are people who are saying prior times you've been violent to her. She's told her friend he punched me in the face. Her friend has witnessed you dragging her down by the ear. There are teachers and staff who saw you bend her hand and make her cry and go at her even when they tried to stop it. So you have a history of all sorts of witnesses who have seen you do violence to her and accept no rules or controls. What a horrible set of circumstances if you're innocent that you have that track record with the very same girl who was killed randomly on May 9th. It's a rough set of circumstances for you to be an innocent person. But here's another horrible circumstance if you're innocent. There's been prior concerns that the family can even tell us about, and that some of your friends and her friends can tell us about, of you lurking around their house. Remember, the murder happens at the house, right? So who do we have track record of being at the house inappropriately at times they shouldn't when they've been told not to? Oh my goodness, one person, the defendant. So again, this one girl is randomly murdered, and you're the one who multiple people can document have lurked at her house inappropriately before. A horrible circumstance, horrible, unlucky if you are an innocent person. And then this murder is committed with a gun, right? So, again, you're 15, that seems like that would clear you. But a horrible circumstance. There's all sorts of people who say, during this same time period, you've been trying to get a gun. Well, that's unlucky, right? If you're innocent, you're trying to get a gun at the same time she's murdered with a gun. And here's how horrible that luck gets, okay? Because when we recover a gun, the gun looks like the same gun that you had. Because we start hearing from people who took a picture of you with the gun, who when they're showed the gun, they say, yeah, that looks like the same gun. So it appears that by some horrible circumstance, if you're innocent and falsely accused, you have the same type of gun. A gun that looks the same as the gun that is the gun that kills Kaylee Juga. what a horrible coincidence if you're an innocent person. And then, here's a horrible coincidence. It's a cousin of yours who takes the police, who otherwise are never going to find this gun, to a sewer in Racine where they find the very gun that is the murder weapon. Okay, so you didn't kill her, but your cousin is able to lead police to the murder weapon, which looks identical to a picture we have of you with the same gun and to what your friend says is the gun you showed him, just days before the murder. But why, if you're innocent, would your cousin be able to bring us to the gun? And why would the gun be located very close in proximity to where you are arrested, to by Aunt Shanice's house? That's a horrible coincidence. And in fact, it's even wrapped in a diaper that is an identical size and brand of diaper to the diapers located at Tina Heron's house, which is the first place that you were taking shelter in Racine. So literally, not only is the gun found in the same place that near where you are, not only is it shown to us by your cousin, but it literally it is wrapped in a diaper by the place you were first when you got to Racine. This is a horrible set of combined bad luck for an innocent person who is falsely accused. And not only that, but this cousin who finds the gun for the police in a place they would never have otherwise found it, in a sewer where the grate is on there, right? But when we look at your Facebook records, you, this innocent person, that's exactly the person you were contacting right after the murder to come and help you. So, you're innocent. The same guy you've been in touch with immediately to come and help you brings us to the gun. And here's how unlucky you are. Eventually, when your cousin does tell us where the gun is, he also offers to us a gun we would never find otherwise. He says, yes, I was handed this gun by the defendant and asked to get rid of it, and I'm the one who threw it in the sewer. So, let's say you were the cousin and you were just trying to get responsibility off yourself. Would you ever admit you were the one who threw it in there? Never. Why would you ever say, I'm the one who threw it in there? Because finally you decided to tell the truth. Just like taking us to a place we would have never found it is showing us you're telling us the truth. And at those moments, those final truth-telling moments, here's how unlucky you are. That's when it's very clear that your cousin, your own cousin, is saying, you, the defendant, are the one who gave us the gun, are the one who gave me the gun, which is the murder weapon. How could this happen to an innocent guy? Why would, while I am showing you a gun you would never find, why would I say, you know what? Randomly, I'm going to show you a gun you would never find, and I'm going to frame my cousin. I'm going to frame my cousin randomly for a murder he didn't do. Who would do this? How could this ever be reasonable? That you would combine showing an undetectable gun and framing somebody else at the same time. And here's how further horrible your luck is if you're an innocent man. Because all of the things I've talked about would have to have already happened to you, right? But then we'd have to find out from Alexis Fertney and from Desiree Flores, from two different sources, that you are mad at Kaylee on the very day that she's murdered. You guys have been broken up for 3 months, 2.5 months. Now we know you're mad at her and expressing that to multiple people on the very same day she's murdered, right around noon. Unlucky that this person randomly murdered, you didn't do it, would have that going on. And you'd have Alexis Fertney saying that she dropped you at Ezra's, which means we can put you at a apartment that is directly across 104 from Kaylee's subdivision. And here's how unlucky you are. When you were dropped there, sometime around 1:30 or so, when you're dropped there, you're wearing a gray hoodie, and we know this from the Steins video too, but we also, and from Alexis Fertney house video, but we also know it from Ezra Stargell and from Alexis Fertney. So we have 4 sources knowing you're dressed in a gray hoodie, blue jeans, white shoes, and you have a black backpack. Okay? So on a random day, those are the 4 things we know about you, right? Well, here's a horrible, horrible circumstance if you're innocent and falsely accused, because you leave Ezra's right around 2 o'clock, unless Ezra is framing or lying about you. That's what he says, right around 2. And Ezra says he sees you leave on a bike. In fact, he identifies that bike. And here's how unlucky you are. That bike is a bike that Melinda Bowens says you took from her house. So Ezra sees you leave on a bike, which we also can trace to you from Melinda Bowens. It's just at around 2 o'clock. You're on a bike. And then within just a few seconds, here's how unlucky you are. There is video from within the subdivision of an individual wearing a gray hoodie, blue jeans, white shoes, with a black backpack, with a black bike, which the detective has said to you looks to him in close comparison as the same bike on the video. And that bike is headed towards the park. And if you keep going, of course, your route would take you to Kaylee Juga's house as well. So horribly bad luck for you that the only bicyclist through this area is wearing identical outfits down to the backpack and shoes that you are, and riding a bike, which a person like the detective and the other witnesses says is a match to what you left on from Ezra's just minutes or seconds earlier. So that's just right around 2, just after 2. We know that Kaylee and her mom get back at 2:20. And we know that affords you, and this is unlucky if you are a person who is falsely accused here, that time between just after 2 and the time of the entry into the garage, which is about 2:56, gives plenty of time to change, plenty of time to make sure that no one else is home, to wait for the mom and Kaylee to get home. It gives you plenty of time to get up your courage and to get yourself ready to do what you're going to do. You do not make the 2:40 preset time that you set with Lexi to come and get you. You are not there for that. That's unlucky, right? Because if you were there at 2:40 as an innocent guy, we'd know you weren't the guy dressed all in black at 2:56. We would know that. But you blew Lexi off at that time. Okay? And then later, as she drives home, after the 3:02, after the murder, then there is this desperate communication, please come and get me in a hurry, hurry up, that happens after the fact. So then here's something unlucky. The person who approaches the house, it's not you because you're innocent, right? The person who approaches the house at 2:56 p.m., do you remember? He actually goes through the neighbor's grass and yard in an apparent effort to avoid the windows, which would be Kaylee's room and the mom's office, and the video cameras. Okay? Which appear not to have been working with. You wouldn't know that, right? So the idea is, I am hugging an area where I'm not going to be seen, and this person who does the murder is actually willing to walk through someone's yard and grass and jump their fence. Now let's say that I don't know this house, I don't know what those windows do, I'm not familiar with the fact that they probably have cameras in certain spots. Let's say I haven't scoped this place out. Would I risk walking through the neighbor's yard, in their grass, and jumping a fence out in the open? I submit to you, here's how unlucky the defendant is, no one would ever do that. If you were thinking, hey, I want to rob somebody in there, I want to burglarize, I have some other motive other than domestic violence, there's no way you would take the chance that somebody would see you walking through a yard, that neighbor could be home, there could be 100 reasons why you bring attention to yourself by doing that. The only reason you walk through the grass in that yard next door and jump the fence of the yard next door is because you're so conscious of how the Juga house is set up that that is your priority, to avoid somebody in the Juga house seeing you first or being on any kind of film that the Juga house would have. And again, why is that so unlucky? Because the defendant is a guy who would know that whole layout. A random person would not. And so it's really unlucky that everything about the approach to this house by the murderer is consistent with somebody who knows that house well. That's unlucky for you if you are innocent and falsely accused. You approach from the direction of the park, you flee back towards the park. The person who does this is wearing a black sweatsuit, right? Black hoodie, black pants. And here's something that's a little unlucky for you. Desiree, who saw you 3 days ago, 2.5 days ago, when you spent the night there, said that's how you were dressed when she saw you last. When she saw you last, that was the outfit you were wearing. And here's something unlucky. We don't find that outfit. And we don't find the white shoes either. Well, let's see. Why, if you're an innocent guy, why would we find you in the clothes that you changed into after and before, and not the clothes you had on when you shed all that blood? Could it be that you're concerned we'll find blood on your white shoes, or you're concerned that there'll be specks of blood or matter on those black clothes, and so you got rid of those just like you thought you got rid of the gun? Really unlucky that clothes that Desiree says for sure he had, that white shoes that multiple people said he had, and that we even see in the video from earlier that day, really unlucky that those things are now mysteriously gone when we take him into custody on the 10th. Those things are all disappeared. Gee, that must be a horrible and unlucky coincidence for an innocent man falsely accused, that the clothes that a murder was done in are the only clothes missing. And the rest of the clothes we've seen him in, we have found. Unlucky if you are falsely accused. So the bike's identical. The clothes that you come to and from after changing in the park appear to be identical to your clothes. And all of those things are just horrible luck for a guy who has motive, a guy who has a gun, a guy who has the same type of gun, a guy who said he wanted to kill her and has all the motive, etc., everything else I've talked about. So here's another unlucky piece. Alexi Fertney says, after I pick him up, he's in a hurry to get out of Ezra's area there, and he is crying. And by the way, the shoes that I noticed were white before and were clean Now it's been, maybe an hour and a half or so, 2 hours since she's seen him. Now those shoes are muddy. And you heard the detective say that the park, etc., was muddy on that particular day. So somehow he's gotten his shoes muddy at the same time that this incident has occurred, though he's innocent and he's falsely accused. And here's an unlucky part. Lexi Fertney says, you're crying when you're in the vehicle with her, you're not yourself, it causes her to cry, and you tell her a story of a group of girls killing Kaylee. And here's unlucky for you, we know from the video that that's just not it. That's just not true. That is deception from you. So, it's unlucky that Dontrell Seymour ultimately tells us that while he is providing you transportation to Racine, you tell him, I did something, she gone. That's unlucky that you either said that and the explanation that's logical is that you killed Kaylee Juga, or that for some reason he is framing you today. And here's what's really, really crazy unlucky. Desiree Flores Wyrock, not related to you, not one of your cousins, not one of your framing you cousins. Desiree Flores Wyrock, who is friendly enough to you, she'll let you stay at her house and will listen to you when you say things like, I'd like to kill my ex-girlfriend. She reports on May 6th that you asked her to help kill Kaylee and you said you had a gun. She reports, and we showed evidence that on May 7th at 6:54 p.m., you sent her a text, and we know it's him because it's consistent with what he told her the night before. Do that hit with me 100%. And then just hours before the murder, Desiree Flores Wyrock confirms, and we have evidence that a text or that communication was made at 11:52 a.m. saying, I'm so mad, you need to do that to her. So, if you are innocent and you're falsely accused, why is this random person, Desiree Flores Wyrock, who I believe my co-counsel artfully said, if you're getting some kind of deal, how come you keep getting charged again and again and again with new charges, right? So it's the worst. There is no evidence there's any deal. In fact, there appears to be the contrary. And she, in custody, came here and told you this person, who she identified, wanted her 3 separate times, the 6th, the 7th, and the day of the murder, the 9th of May, to help kill Kaylee Juga. If you're innocent and falsely accused, then you are also a person who is also trying to have her killed that day, and yet you are not responsible for her death. That's how unlucky you would have to be. And then a couple weeks before, you get Kyle Bowen to give you some ammunition for this gun that looks the same. And you're given the wrong bullets. Okay, it's .380 ammunition, 9mm pistol. And the ammunition that Kyle Bowen gives you has a very particular stamp on it, right? It's a particular a brand, and so it has its own stamp. Here's how unlucky you are. You got some of that ammunition from Kyle Bowen, and it's wrong for the gun, so that's weird, okay, that coincidence is true, because the murder is, again, also a crime that occurs where someone is using a 9mm, we know because there's a murder weapon, and they're using .380 ammunition. So the mismatched ammunition is the same circumstance you yourself have in the gun you have, even though you didn't do this, okay? That's how crazy it would have to be for this to be an innocent man. But remember, though, too, even more particularly, here's how your bad luck would be. The stamp on that ammunition from the Bowen household is the same as the bullet that's found, apparently dropped on the sidewalk by the park where logically you would hide your bike and you would change your clothes. Okay? So a person engaging the gun or doing something with the gun might drop one of those bullets And again, it's that same type of ammunition. And in Kaylee's room is another one of those spent casings with that same Kyle Bowen's brand ammunition. I mean, what are the chances? What are the chances that you did not do this and that it's reasonable that these things would occur? Okay, now, I haven't even gotten to the most powerful piece of evidence in this case, guys. I haven't even gotten to the part that simply could not happen in any conceivable way consistent with the defendant's innocence. Because Ann-Shanice Andrews is done with her interview. She is literally being escorted out of the interview. And a detective says to her, what if your daughter was in the situation Kyle was in? What if you were the Juga family? And she stops the detective and says, I have more to tell you. This is the defendant's cousin, who in that moment of conscience, right? In that moment, thinking about the Juga family and the loss, said, I have more I can tell you. He confessed to me. And then, as you've heard us a couple times say, but I'm going to cover one more time, there are a number of things Ann-Shanice knows about this case, that many of which the police do not even know yet. Okay? Here's what that would mean. If Ann-Shanice is able, in the very early morning hours on May 10th, to provide the information, the defendant, my cousin, confessed to this crime, with these details, then she has superhuman psychic ability. Okay? She can predict the circumstances of a murder before they are known to the general public, before they are even known to the police. And that superpower that she possesses, for some reason, if this is an innocent man, she uses that superpower on this day to try to frame her cousin for a murder. A person who no one's identified that she had anything against. That is what you would have to believe. Because Ann-Shanice Andrews says that the defendant told her that that Kaylee, the victim, was mad at Lexi, where the place he was staying, on that morning. Well, how would they know that? I mean, no one had talked to Alexis Fertney fully yet. The law enforcement would not know that. Certainly that was not out there in any fashion in social media that she would have any access to. Ann-Shanice said that the defendant, her cousin, said he was dropped by a friend who was driving him around. Well, how would she possibly know that? How would she possibly know that that's how, the mode of transportation? Ann-Shanice Andrews said he biked into a park. No one knew that yet. No one had reviewed this video at the time Ann-Shanice was being talked to. So there's no evidence in this record that anyone knew that except the defendant at the time of the incident, at the time Ann-Shanice shared that information. She said, he told me he went into a park and he changed into dark clothes and he had white shoes. Well, that's exactly right. That's exactly what we know after we look and compare the videos. And how, under any circumstances, would she know that? The law enforcement did not have any idea of that yet. She predicts actual true facts before the police have any idea. And Shanice said that he jumped the fence. And again, we know that from the video, but that video had not been reviewed or in any way looked at, and certainly wasn't available on social media at the time Ann-Shanice Andrews gave that detail. She indicated that he said Kaylee was playing music in her room. And no one knew that until Stephanie Juga was spoken to at the hospital after that. There's no way that anyone would know a detail like Kaylee was listening to music in her room, which Stephanie confirms at that moment. How would you know that detail without psychic abilities or having heard it from the defendant? He said that her mom was in the other room, that he shot her mom twice That wasn't publicly known. No one knew how many times she'd been shot. How would that be something Ann Shanice Andrews would know unless the defendant told her? How could she get that right? And that she was shot when the mom opened the door and then she tried to close it. Well, that's exactly what Stephanie tells us. But Stephanie had not even been able to go through that version with us because she was still in the hospital under critical care, and there was no way the detectives involved with Ann Shanice knew those details yet. She said the defendant told her he shot Kaylee in the face and something about that there was a black on her face. And that is the one that sent chills through me. Because you heard Stephanie say that, you heard that first officer, Deputy Eckert, say there was black mark on her face. How would Ann Shanice Andrews know that? Unless the defendant had said it as an observation himself. He texted a friend to pick him up. That's exactly what happened. How was that available to Ann Shanice at that point? And then here's the other one that sent the chill through me. He told a mom of a friend, don't tell the police I was there. Okay, again, that's not the kind of detail anyone had. Easily accessible at that point. That's not something that was in social media. It's not in writings about the case. But when you heard from Alicia Stargell, okay, the mom of a friend, she says, he told me, if anyone comes, don't tell them I was here. So again, how would Ann Shanice know that? So I'm almost done. All of those things from Ann Shanice Andrews could not be known, could not be accurate and right. Even the police didn't know them, many of them, at the time they first spoke to her, unless the defendant had told her, that those had occurred. And so for her to make those things up and be right and be framing him is beyond any reasonable belief. It is not a reasonable basis for doubt. Now, the last piece I want to talk about in terms of that is this interview with Detective Dietz. So, the state put that in. We said, here's what he told a guy who he knew from coaching, because Detective Dietz works for KPD, but he also, coaches at Bradford, so he had some interaction and relationship with the defendant already. And what happened in that interview, from the state's perspective, also is something you should consider, and goes to this idea of how, if this was an innocent man, these things just wouldn't happen. Okay? All of these things would not happen to an innocent man. So why do I say that? Because what the defendant offered to Detective Dietz was this. Essentially, I did not kill Kaylee Juga. Instead, here's what I did. I was over at Lexi's. I got up around noon. I had some pancakes that she brought me. I walked from there to my mom's house. I got to my mom's house. My mom had a baby over. My mom and I interacted. And then I decided to go take a nap. And so I napped till sometime 2:45, 3, at which point I began to walk some paths at Parkside. And that's my explanation for my whereabouts. I was by myself walking the paths at Parkside. Let's think about that moment. If you are an innocent man falsely accused, well, here's your moment. You know Kaylee Juga is dead. You know you're not being talked to at random. So if you are an innocent man, what you would do is you would say absolute truths. Because this is that moment, right? This is the moment for absolute truths, if you're an innocent man falsely accused. If you're guilty, though, you're going to lie. Okay? You can't tell the truth, so you're going to lie. And you're going to tell lies and hope that they can't be proven. Okay? And here's what you know. You know that what he chose to do was tell lies. You have the video, you saw a snapshot at Stein's. You have the testimony of both of the Stargels. You know, they're making this up. The Stargels are lying about what happened at their house on 2 parts of that early afternoon. When he says he was at his mother's house or at Parkside, he was at the Stargels' house. Lexi Fertney, who says I gave him rides during the times he says that she wasn't with him and that he was at his mother's house. Okay? So all of those individuals, and then you have Cole Ballard, right, who says I spoke to him on the phone at 3:20 during the time that, according to what he told Detective Dietz, he'd be at Parkside by himself on some park path or on a bench. And Cole Ballard says, I spoke to the defendant by phone. I know him. He's a friend of mine. I know his voice. And he wanted me to come and pick him up at Aurora, which is right by Kaylee's house, right? So we know from Cole Ballard, who otherwise, what, is he going to frame people? Is Cole Ballard a part of some huge frame up here? That isn't, that what he chose to tell Detective Dietz is a pack of complete and utter lies. And again, if you are an innocent man and falsely accused, it is horrifically bad luck that you chose that moment to lie your rear off about where you were. Really bad luck. Then I just want to talk for a split second about tampering with the jury the last time, because again, that goes to consciousness and guilt. Okay, an innocent person does not feel that they need to again try to manipulate every friend and relative they can think of. Possibly getting these people in trouble, right? Telling them, hey, get in touch with this person. I can't say much. They're recording the calls. Don't make me talk about it. But, do you remember what I said? Do this, so forth. All of this sort of manipulative direction of those people still trying to stick around and stick by him is what you do if you are guilty and you simply are doing everything you can think of to avoid responsibility. Ladies and gentlemen, when you think about all those things together, you will conclude there's no way all that stuff could happen to a person who is innocent and falsely accused. The only reasonable explanation is the defendant is guilty of the offenses we have considered here today. The defendant killed Kaylee Juga. He entered that house with a gun. He tried to kill Stephanie Juga. He took away so many things that we have grieved over in this room over the last several days. He stole them away. He stole them away because of his absolute need to be in control of situations. Your verdict today will take that control back and will tell this defendant, it is about the rule of law. He doesn't get to control. You, the jury, do. And so I ask you to find him guilty and hold him responsible for those heinous crimes that he has done. Thank you.
Jury, how you doing? Do you need a break to use the restroom or anything before we start the next argument? Okay, we'll do that. We'll just take a quick run down, and we'll be, as soon as they're ready to come back, we'll be ready to come back. please be seated. Mr. Johnson.
This is a difficult case. There's no doubt about it. It's a sad situation. It's a tragic situation. But your job is not to decide that. Your job is to look at the evidence and to decide whether the state has proven its case beyond a reasonable doubt. In a little while, the judge is going to give you a jury instruction. And what that instruction says is that the time has come now when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors. Selected for this important duty, you will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. It's a really important job. But when you look at the state's case, you're going to see that there's some holes. And they have the job, they have the burden to prove their case to you beyond a reasonable doubt. Even as we sit here right now, Mr. Fuller still has the presumption of innocence, and he maintains that presumption of innocence until the state proves otherwise, until you decide otherwise. So let's talk a little bit about reasonable doubt. There's not anything that says it's, a certain number that says, oh, I've got to get to I'm 90% sure or I'm 85% sure. But I like to think of it as the big decisions that we make in our life. So when we buy a house, when we decide if we're going to marry someone, if we're going to have children with someone, even buying a car. And a reasonable doubt is a doubt for which we can give a reason. So I like that car, but every time I touch the brakes, something's squeaking. It's making me nervous. I've got a reasonable doubt about buying this car. That house was perfect, everything looked great. Home inspector thinks the roof needs to be replaced. Not sure I want to buy that one. So those doubts that kind of keep you up at night, that keep you thinking. And you start analyzing it and thinking about it, but those are the ones that you just can't get rid of. So I want to give you a little bit of a roadmap of where I'm going to go. And I'm going to try hard to stick to that roadmap. First, I want to talk to you about what's missing. Clothing, DNA, fingerprints. I want to talk to you about some of the witness testimony that you've heard over the course of this last week. Talk about the timeline that the state has presented to you. And then to talk about the physical evidence. So let's talk about what's missing. And it's no secret that the black sweatsuit and the white shoes are missing. The police think, and the state has said, they think that Martice changed his clothes, put on a black sweatsuit, and entered the Juga home. Don't have the sweatsuit. And it's not for lack of trying. We know that they searched 4 different places that they think that Martice had a connection to. They looked in Horizon Park. They looked around Ezra's house. Detective Kennedy said, we were looking for them. We were looking hard for those clothes. We don't have them. And they don't have them to be able to test for DNA, to figure out if there's an initial on the tag that says Martice or MF. There's nothing there to be able to have those clothes to see, are these the clothes that we can see in that video? And do they belong to Martice Fuller? And there's not witnesses who say, I saw some kid changing his clothes somewhere in that park by my house. That's something that's going to draw attention. People are going to notice if someone is doing that. The police check the wet park. They don't find bike tire marks. And apparently the ground was wet enough, the state says, to have mud on shoes, but not for a bike to leave marks. You heard from an analyst from the state crime lab, Ms. Fisher, about DNA, and she told you, here's why I don't think there's DNA on this gun. She also said, though, that was all I had. I was asked to look at swabs from a gun, that was it. Not swabs from the door handle between the garage and the inside of the Juga home. Not the stair railing. Not anywhere else in the home to try and figure out, was someone in there and who they were, someone that didn't belong. Stephanie Juga on the 911 call said it was Martice Fuller. Police took that and they ran. They didn't try and figure out, can we get some physical evidence such as DNA, such as fingerprints, just to be sure that that's right. But they heard that name, they got tunnel vision, and off we went. So let's talk about the witnesses. Stephanie Juga testified in this case. She was going through terrible things on that day. I cannot even imagine. But I also know that when I'm going through unimaginable things and scared and frantic and panicked, I'm not at my best. And you can hear it in her voice on that 911 call. She's not sure of how old she is, and she is just distracted and panicked. And understandably so, but that's the reality of the mental state at that time. And the judge told you, when thinking about when someone identifies another person, she gave you a kind of a list of things that you should consider, and one of them is the mental state of that person. And so think about how scared, how panicked, and how distracted Stephanie was when she made that identification. And certainly at the time that she made that identification, there was a lot that had kind of led up to it. Martice Fuller was not high on anyone's list at that house, that's for sure. So he would be an easy person to assume that that's who it is. And I want to be clear, I'm not saying that that Stephanie Juga came up with this sinister plan. But when you think of where she was at that point in those moments, there's every reason to believe that she's mistaken. And we've all, I'm sure, been in situations where we've been panicked, where we've been fearful. And we all know that that is not the time when we are at our best, when we're making good decisions. And we know that our memory can be affected by that. There was also talk about cameras. And the state has gone to lengths to talk about this person in the black. They kind of hug along the house. And the state says that's because it was Martice Fuller. Martice Fuller knew that there were cameras. He knew where the bedroom and the office were. And so he wanted to be close to that house. However, we also heard testimony that there are cameras inside of the Juga house. Now, they're not always working. But we also know that they get moved around at times by Nick Juga. So if you're someone who knows the house, you know kind of what goes on in the house, and you know enough to know there's cameras on the outside, and you know other things according to the state, you're taking a big risk by going to this home with cameras on the inside. You're taking a big risk that as soon as you walk in that door from the garage, there's not going to be a camera pointed right at your face. We also know that Stephanie Juga's description of how many shots that she heard is not the same as how many casings are found within the home. And again, I think it's evidence of where she was in that moment and that her memory is off and it's inaccurate about what happened. And you may feel a lot of sympathy and empathy for Stephanie Juga, and that is completely fine and that is completely natural. I think that's probably the only human response that we could have. But I'm talking about her memory in those moments and the reasons to doubt her memory. So the judge is going to tell you, as I said, that your job is to evaluate the evidence, to look at the evidence, but to not be swayed by sympathy, prejudice, or passion. And so that's what I want you to do when you think about that testimony and think about the identification that was made. We also heard from Martin Torres. And Martin Torres, we know, had Martice Fuller's Facebook account up on his phone for about a month or so, and at a time when he wasn't seeing Martice. And so he had complete access to that phone. Now, Martin Torres says, I never used it, which is not surprising, but he had every ability to do that. He had complete access to that account and the ability to impersonate Martice Fuller. We know from Alexis Fertney, who is, the state says, the first person to see Martice Fuller after they say he committed murder. She doesn't see a gun. She doesn't see any blood. She doesn't see a black sweatsuit. There was Dontrell Seymour. And I will say this, that I appreciate that Dontrell was willing to kind of own it. Because he said, I lied, and I lied over and over and over. I felt like they were coming after me, and his first instinct was to lie. You heard his testimony. You heard him admit that he lied. He's not credible at all. You heard from Ann Shanice Andrews. And the important piece of Ann Shanice Andrews is that she says, I was not close with Martice. I wasn't close with his family, his father. He didn't come around family. But she says and expects us to believe that this person who sort of a semi-estranged cousin has basically just emptied their soul to her, has told her everything, confessed to murder to her. It just doesn't make sense. Jennifer DeZoma testified, and she talked about some incidents at Bradford High School that she says that she witnessed, that were around other people, that were in areas where there also, in addition to students, there would have been staff, there would have been security cameras. And she says nobody does anything. She says Martice Fuller yanks on Kaylee Juga's ear. Nobody does anything. Nobody intervenes. He punches her in the nose and causes bleeding. Nobody does anything. Nobody says anything. Nobody notices that her nose is bleeding. It just doesn't make any sense. And I understand this is a hard situation for her. Jennifer DeZoma is dealing with issues that are well beyond what some teenagers should have to deal with. But it doesn't add up what she says she observed and what she says happened. A student assaults someone in the middle of a school and causes bleeding, and nobody notices. The state also had Brian Martinez testify from Martino's Dry Cleaning. And he says, there's these phone calls, they block these phone calls. You have seen no evidence of phone records from Martino's. You've had nobody say, at least from law enforcement, nobody has said, okay, the number that called Martino's was this number. We know that this number is Martice Fuller's, and this is how we know that. You didn't hear any of that. And you heard a bunch of witnesses say Martice didn't have a phone, or a phone that functions as a phone. He had Wi-Fi. Desiree Flores Wyrock, she's got her own problems right now. She made some additions to her statement after she had been charged with crimes and after she was meeting with the DA's office, the same one that was prosecuting her and is prosecuting her again. And she understands the predicament that she's in. She understands that this district attorney's office has a lot of power and a lot of leverage over her, and she better make them happy. And so she has every reason to do or say the things that are going. And so through this investigation, the police have received information that was not completely true, was not completely reliable. And sort of the bad inputs make bad output. So if I have a soup that I'm making, I put all these ingredients in, but I got some in there that are rotten or no good, that affects the whole thing. That affects the entirety of it. And so that's what the state's presented to you. They presented to you this case with certain things that don't make sense and that impacts the entirety of that case and should cause you to have doubts about it. So let's talk about the timeline. And I think that the purpose of readdressing that issue this morning was to try and make it less confusing. I came out of it more confused. But basically what the state's theory is that there is someone who rides through the Horizon subdivision and goes past 109, 19, 69th Street, and they're going westbound at that time towards the park. Now yesterday, Detective Kennessy said when we were watching the video that didn't have a timestamp, he said that happens at approximately 2 o'clock, that an individual with a gray sweatshirt and jeans is riding westbound. Now the state is saying, no, it wasn't really 2 o'clock. When we put it on this different player, it shows a different time. It shows later than that, closer to 2:08, 2:10. And so the timeline shifts depending on what media player it's on. But you know what we saw yesterday. We saw a video from 109-19, 69th Street. And Detective Kennessy said there's a person going westbound. On the timer for that player, it happens at 35 seconds. On cross-examination, I said, can you please move it up to 54 minutes and 37 seconds? And there's a person going eastbound. We're not playing a trick on you. That you saw it, okay? But the state puts it on a different player, uses a different computer, and everything gets kind of confusing. And so the point of that is I think there's reasons to be very skeptical about a timeline. Because the things that the state, well, Detective Kennessy said approximately 2 o'clock, then it changed. We have this new player. The new player changes around kind of what we see as far as time goes and then what that means for the state's timeline. And so things are not as clear as the state wants you to believe on their timeline. What the state believes happened is they're saying that Mr. Fuller goes into the home, shoots Kaylee Juga, shoots Stephanie Juga, comes out at 3 o'clock, runs westbound, finds someplace where nobody's going to notice, changes clothes, gets on a bike, and then they have him at 109-19 69th Street, they say, at 3:03. That's not a lot of time to do all those things. And Detective Kennessy said, well, I think it would take this long to ride a bike to here, or to run from here, and to get to this place, to that place. But ultimately, it's your choice, and it's your decision. You don't have to take the testimony of Detective Kennedy, just as you don't have to agree with or take as true the testimony of any witness. It's up to you to decide for yourself. And then let's talk about the physical evidence. Yesterday, Detective Kennedy looked at the video. He showed you the video. He said, I can't tell the gender of the person in that video outside of the Juga home. I can't tell the race of that person. Now, he does say that he can see blonde tips on dreadlocks of someone riding a bike on the video from 109 1969th Street. Again, you get to decide that. Okay, my eyes are not the greatest, but I can't see it, okay? If I got my contacts in, I'm not that far away, I can't see it. You get to decide whether you can, okay? But I don't think it's there. And so again, you get to decide, is the person who I see on this bicycle and the person who goes into the Juga house, is that the same person? And there were some comparisons they did. It's your decision, okay? Because Detective Kennedy says, well, when I compare this, I compare that. You don't have to listen to him if you don't want to. You get to decide. You also heard Officer Valeri testify about ejection patterns and different things at the crime scene. And what I just want to highlight is that when she comes to the scene, she knows what she sees when she gets there. She doesn't know how things get to their final landing place. We've got a projectile on the stairs. We've got a casing down on the first floor. So she can say that's where they are when I see them or when I recover them, but she has no idea the story of how they got there, how they traveled there. And let's talk about the tool marks. So I think the first thing that's important to highlight is that there's an assumption that kind of overarches tool mark examination, and that is that every gun leaves distinctive markings. So although there may be thousands of the same type of gun, same manufacturer, same caliber, and even maybe manufactured one after another, that each one of them would leave a unique and distinctive marking that this examiner can identify on a small object, on a projectile or on a casing. And that there's going to be that each one of those would leave that unique and distinctive marking. So we talked about what's the standard or what's the evaluation that happens. And so the examiner looks at this object on the left, looks at this object on the right through a high-powered microscope, but they're looking at the two things. And it's up to them to decide what I see here looks the same as what I see here, or it looks similar enough that I think that there is sufficient agreement. So the tool mark examiner, Ms. Williams, she said it's a match. That's not exactly what the standard is. The standard is, does she believe there's sufficient agreement between this one and that one? And sufficient agreement, if you remember, has this long and confusing definition. That is, when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. So when she says match, that's not what it is. She's saying there's sufficient agreement when I look at this thing on this side and this thing on this side, and I've examined them with my own eyeballs, and that's the decision that I've made. It relies an awful lot on her. It relies on the fallibility of humans, of us as people. The state has described what it says is stalking behavior. You have not received an instruction about making a decision about whether Mr. Fuller stalked Kaylee Juga. He is not charged with that offense. It's a diversion. It's to gain sympathy and appeal to your fear in this case. Your decision is to look at the 3 charges that Mr. Fuller is charged with and decide whether the state has met its burden beyond a reasonable doubt for those 3 charges. It is not to decide whether he was engaged in this stalking type behavior or this domestic violence behavior that the state says that he did. So as I said when I started, there's some big holes in the state's case. There's those lingering doubts and questions. What about the clothes? What about the timeline? Was Stephanie Juga's memory able to take in this information? Was she able to be accurate in her reporting under the stress, panic, and fear that she was under? Can we trust what the witnesses have told us? Do we trust the things that the state has presented for their timeline? All of those things. And so those things are here, and those are doubts. They create the doubts in this case, those reasonable doubts. So again, it's the state's burden. It's their job to prove their case to you beyond a reasonable doubt. And they haven't done that. And so we ask you to return verdicts of not guilty. Thank you.
Thank you, Mr. Johnson. State's rebuttal.
There are no holes in the state's case. We told you in the very beginning that any case is putting pieces of a puzzle together. No one person knows the whole story except Martice Fuller. So what we do is we take testimony from each person who was manipulated and used and abused by Martice Fuller. And from there we follow those threads to the whole story, to the truth, to see where it leads. Attorney Johnson said the jury instruction will tell you you must reach a just and fair verdict. And what is just and fair is a guilty verdict in this case. The jury instruction also tells you you are to search for the truth. You are not to search for doubt. And a reasonable doubt is not a doubt based on guesswork or speculation. And that's what you have been asked to do right now. To guess and speculate and disregard the overwhelming evidence that you have been presented with. The identification of Martice Fuller by Stephanie Juga is without doubt accurate. She had this person in her home over the span of 10 months, for hours at a time, talking to him face to face, listening to his voice, looking at his face. She told you she relives what happened every day. She sees it in her mind every day. Despite her efforts to diminish those memories, those horrific memories, by putting up photos of Kaylee throughout the house, she will never forget. There are some memories that are burned into your brain forever. She sees his face. She hears his voice. She sees the gun being leveled at her chest every day. She hears his words when she says, "You don't have to do this." "Yes, I do." There's no confusion about this. She tells the 911 operator on multiple occasions that it is Martice Fuller, her daughter's ex-boyfriend, who shot her and is in her home. She knows and tells the 911 dispatcher his mother is Alice Fuller. She tells the dispatcher he's mixed race. He's half Hispanic, half black. She gives them their address. She says, we are 4 blocks away from Aurora Hospital. There is no confusion in her brain, in her mind or in her memory. Yes, she's frightened. She doesn't know what's going to happen to her or what has happened to her daughter. But that moment in that hallway where she sees Martice Fuller is something that she has no doubt about and will never forget. Perhaps what Attorney Johnson has asked you to do would make sense if we had only one of those witnesses and not all the others. Well, disregard Ezra Stargell, disregard Dontrell Seymour, except you have all of them. You know, Attorney Gravely told you how impossible it would be for you to be not guilty with each of this evidence all presented together. He knew when they would be home. He knew their schedule. And you know what? Ann Shanice Andrews, when she testified, she told you that. She said, Martice told me that he knew when they would be home alone. He watched them. He watched Stephanie and Kaylee Juga go into their home that day. How would Ann Shanice Andrews know this? What reason does Ann Shanice Andrews have to make this up? She may not be close to Martice Fuller, but do you really want to falsely accuse someone of first-degree homicide and attempted first-degree homicide if they have not confessed to you? This is no false confession. This is no false accusation. She knows what she knows because Martice told her. Attorney Johnson asked you to look at what's missing in our case. We're missing the black clothes. We're missing the white shoes. That the police did a very thorough search to find it. They looked around Ezra's house. They looked around Horizons Park. They searched a few homes. Yes, they did. They did try their level best. But you know what? You know what would have been missing if not for Dontrell Seymour? The gun. We only found the gun, the police only found the gun because Dontrell Seymour led them to it. In a sewer in Racine County. I wonder where the idea to drop something into a sewer came from. How many sewers are between Kenosha, Horizon Subdivision, and Racine where the black clothes and the white shoes could have been dropped? Why else would Martice Fuller get rid of his white Nike Huaraches? Why haven't they been found if they were not deliberately hidden, concealed, to prevent law enforcement from finding the evidence that Mr. Johnson wants us to, or faults us for not finding? Attorney Johnson said they don't even submit the DNA from the house, from the door handle, from the stair railing, because the police were so focused on Martice Fuller. Well, you know what? Even Martice Fuller told Alexis Fertney, that he's concerned he'll be blamed for this shooting of Kaylee Juga because his DNA is all over the house. He's been there so many times. You don't need to look for someone else's DNA when you have an eyewitness identification that is conclusive and all the other facts lead you to the same person. He wants you to not believe Dontrell because Dontrell lied, and Dontrell admitted that he lied. But what you cannot disregard is Dontrell led you to a gun, and it was wrapped in a diaper that matches the diapers found at one of the relatives' homes. Do you think Dontrell just decides to not only falsely accuse his cousin, the person that he's just helped, knowing that there is a manhunt in place, but he leads the police to some other gun? Or maybe he's planted the gun so after helping his cousin, he can then turn the tables and falsely accuse him of this murder? That makes no sense. But that's what you would have to believe to buy into Attorney Johnson's theory. Don't forget that this whole family, the defendant's entire family, knows that he has killed 2 people. That's what they believe. Martice Fuller went to the grandparents' house and everyone starts scurrying to take action to protect him. When Aunt Shanice Andrews drives by, they all want her to come. Come be a part of this. Martice Fuller just killed 2 people. That's what the family tells. The family that just saw this defendant at their house. Attorney Johnson talked about Jennifer DeZoma, that none of what she says can be believed because no one intervened. Jennifer DeZoma told you what goes on in the commons area during the breaks. There's a lot of commotion. You get all those high school kids and all their raging hormones and they're released from a class. No one's paying attention to one another. They're in their own teenage world. So yes, no one saw what Martice Fuller did to Kaylee Juga that day. And no one saw what he did when he punched her in the classroom and caused her nose to bleed. Unfortunately, there are not staff members in every classroom at every moment of every day. And you can only look back on the cameras for the surveillance if you are told something may have happened. Someone's not manning those cameras all day long looking for something that might be going on. That's just common sense. That would require a team of security. He also wants you to not believe Desiree Flores. Desiree Flores, he says, has her own problems. And that is true. Desiree Flores does have her own problems. But that's not what led her to add to her statement after her charges. Desiree Flores adds one thing to her statement after her charges. What she told the police originally is that Martice asked her to kill his ex-girlfriend, that the girlfriend was a bitch and he could just kill her. No, for real, I want to kill her. That he had a gun to do it, that his friends touched the bullets, so he was going to use those bullets. And that he asked her 2 more times to do it. The addition, the change, is that when she spoke to the police, she said, Martice told me he wanted to do it because Kaylee and her mom put him in jail too many times. When the truth of the matter was that he was just angry and hated Kaylee because he had been suspended from school and he could not play football and he was not going to be able to go forward with this football career. That's the only change. That does not really gain her much advantage. It gains her no advantage. And in fact, you heard her testify. Did you get any benefit from this, Desiree? No, I didn't. Did the state promise you anything? No, I didn't. No one did. And Desiree, after you told us that he hated Kaylee and her mom because of being suspended from school, did we, the DA's office, keep charging you with crimes? And yeah, did you see her shake her head? She's like, yeah, you keep charging me, even though, I have given you this information. And then she sat up there and she swore to tell the truth, and she did. She told you the truth, even knowing that we keep charging her, even though she has given us this information. She didn't have to do that. Mr. Johnson says, well, there's doubt because there's not a lot of time to do the things that we saw on video. There's not a lot of time to leave the Juga house, change your clothes, get on the bike, and then ride past. Except really there is plenty of time. You saw Martice Fuller sprinting from the Juga house after the shots are fired. It's about 30 seconds to sprint from the Juga house to that tree line. He was wearing a tracksuit, a warm-up suit. This is what Desiree Flores saw him in a few days earlier. Tracksuits are designed to be pulled off quickly, to be worn over other clothes. That's why they're warm-up suits. He did that. Doesn't take very long to rip off a sweatshirt and rip off your pants, especially if you're not changing your shoes. And he didn't change his shoes. And then it would take another 30 to 40 seconds to ride fast on a bike between that park tree line and the Nest doorbell camera that we saw. What is that? 2 minutes then? According to the video, we have 3 minutes. He's got a minute to spare. So yes, it is logical, it is reasonable, and it does fit with the timeline. There's nothing confusing about it. And there was nothing confusing about that video. Detective Kennedy told you he watched it through and through. You saw the clock this time. The clock says no one rides past at 2:54. It happened at 3:03. The tool marks, you listened to that expert testify, and she is an expert. She talked about her years of experience, the thousands of cases she has worked on. This is a science, and it is accepted across the world. She listed her training. This isn't something we just created because we want to convict people. This is a science. Just like comparing fingerprints, it uses trained experience, education, and eyesight to know what to look for. And what we know is that the gun that Dontrell Seymour leads us to in the sewer is a match to the bullets that were found, the bullets in the casings that were found in the Juga residence, in Kaylee Juga's body, and in Stephanie Juga's body. You can count on that. That is not reasonable doubt. That's wishful thinking, but not reasonable doubt. So when you go back in a few minutes to deliberate, I'm asking you, don't engage in this wishful thinking, in this fantasy that Mr. Johnson would like to create in this case. We have facts, and every witness who testified, there is physical evidence to back up everything that they told us. And you saw it. You saw it on video, you saw it in audio, you saw the guns, you saw the casings, you saw the bullets, you saw the bike. So do one thing that Attorney Johnson told you to do. Return a just and fair verdict. And again, I will tell you, the only just and fair verdict in this case is guilty on all 3 counts. Thank you.
Thank you. Ms. Scheidegger, Mr. Johnson, Mr. Gravely, Ms. Gabrielle, thank you. Now, members of the jury, the duties of counsel in the court have been performed. The case has been argued by counsel. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be given to you. Each one will have a title, verdict, count 1, count 2, count 3. They read as follows. We, the jury, find the defendant guilty of first-degree intentional homicide as charged in count 1 of the information, dated this blank day of March, 2021, with a signature line for the foreperson. And it says, if you find the defendant guilty, if you use this verdict, you must answer the following question. Did the defendant commit the crime while possessing a dangerous weapon? And that has a yes or no with a date line and a foreperson. The second verdict that you'll receive for count 1 reads, we, the jury, find the defendant not guilty of first-degree intentional homicide as charged in count 1 of the information, date, and signature line. A second set of verdicts you will receive for count 2. These will read, we, the jury, find the defendant guilty of attempted first-degree intentional homicide as charged in count 2 of the information, with a date line and a signature line. And then it says, if you find the defendant guilty using this form, please answer the following question. Did the defendant commit the crime while possessing a dangerous weapon? Yes or no, with a date and a signature line. The second verdict is, we, the jury, find the defendant not guilty of attempted first-degree intentional homicide as charged in count 2 of the information. A third set you will receive is for count 3. It reads as follows. We, the jury, find the defendant guilty of armed burglary as charged in count 3 of the information, dated with a dated line and a signature line. And a second one, we, the jury, find the defendant not guilty of armed burglary as charged in count 3 of the information, signature line and date. It is for you to determine which one of the forms of verdict submitted you will bring back as your verdict for each count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict, which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. And if you have to consider that question, that is also a unanimous question. When you retire to the jury, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, you're to send a note through the bailiff, signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read in the record in open court. The court may ask each of you if you agree with that verdict, and then we'll swear the officers. So give me a moment. We need to have, there's 14 of you. So unfortunately, there are 2 people. Connie, would you come up here? Or Jerry, either one. Oh, yeah, that's right. How about the names? Okay. And as I told you before, okay, I'm just about, well, I'll swear you first. So, do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in a private and convenient place, subject to the direction of the court until they have agreed on their verdict or they are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God? Yes. Thank you. Okay, so we have 2 people that, but make sure you take your lunch with you, because I know that it's in there.
Anthony, which one?
Go with them over there and get that. Thank you so much. So, thank you. Okay.
Your Honor, did you, I don't know if you were going to instruct them to essentially stay on call, just in case something were to happen.
Okay, would you do that? Please stay on call, don't discuss the case yet.
Right.
We'll call you. If there's a verdict reached, I will call you. Okay? Okay, thank you. Yeah, nobody's leaving until they're out. And for those of you, I'm going to give you these little folder files. Count 1 has the substantive, and I'm going to put the verdicts for count 1 in there. And then I'm going to put the verdicts in count 2. And I'm going to put the verdicts in count 3. Did you go tell the deputy? Yeah, I want to make sure. I'm going to put the information on the top. You've heard a lot about the information. I've put all the other instructions on the bottom. Whoops, I got to put a few more in there. And she's going to come back and tell us, right? Okay, so we're just going to sit tight till they are out of the jury room, and then you're going in the jury room, okay? Jurors, I also want you to know that, this trial has been broadcast. The people that have been doing the video have avoided ever showing your faces. I want you to know that, and they have been very careful about that and have not done that, and of course, that's a rule of videotaping court trials or jury trials, so I want you to be assured of that.
They got,
You can give them you can give them their books. They can sit here with their books and take them back themselves. You don't have to carry them.
he's looking tomorrow.
I know, but they can, well, as long as we're waiting for exiting. And maybe your pencils are already there. You can grab your pencils and your paper and, okay? You didn't have two? You had one? Everybody got the right one? Good. Okay. I'm gonna have him go this way. No? Yeah, move that thing on the floor. I'm gonna have him come out this way. It's not a shortcut, but okay. Okay, follow Mark, follow Mark. Follow Mark this way. We'll go to our offices that we have, our makeshift offices, and I'm assuming nobody's leaving, right?
We're staying.
Yeah, and Mr. Johnson and you and Jillian will stay? Okay, Now, you all can go get something for lunch if you wish. I would say that, you know, if you're running to get something for lunch, we should be, I mean, I have no way to predict anything, but I'd say you're good for at least 35, 40 minutes, okay? Because they're going to eat their lunch before they deliberate. You tell me when you're ready, okay? Oh, you're ready, okay. Okay. Okay, we're on the record. There's a question or a request from the jury. The jury is requesting that the audio-video of the shooting, the video from across the street, I'm assuming they mean when the sound of the guns are made. So you'll need your video man.
So are you proposing to play that here for them?
Yeah, there's no other way to do it. We're not sending something back, right? So we just let them, okay, so,
He's coming from where? In the building. He's in the building.
we'll let him get set up before we do anything else. Okay, they are requesting the audio video of the shooting, video from across the street, so you get yourself set up. Then what I want is I want them to Okay, so on the record, what, we're playing from what to what? Talk loud so she can hear you next to you. The record.
State's Exhibit 76, file number CAM4 underscore 05-09 underscore 2019 underscore 15-33-30 underscore 15 space 59-59 underscore. And it's going to start at 3:56 and 20 seconds.
Okay.
And essentially go until until the figure runs from the house?
I think we're going to go till it,
It'll go to the end of this file, which the figure running from the house is on the
is on the end of it.
immediately following this one,
Say that, say, I didn't hear you.
separate file.
It's, the running from the house is separate?
Correct.
Okay.
So what are they asking for?
They asked for, the jury requests the audio and video of the shooting, video from across the street.
So does that,
I will ask them when they come in. Okay, they can bring their books and pencils with them.
And Your Honor,
Yes.
I'm sorry, I don't know, is the state requesting that they be told that it's off an hour? I think that's.
If they be told what?
The state had just said something about the time being off an hour. I guess my belief is we should, clarify with them what they want to see.
We'll show them what they want
And no explanation.
and no explanation, but they might want the next video.
Right, if they request that, I think we should
I'll
play
ask
that
them,
for
is that what you wanted? And then we'll see what happens.
do we want to dim the lights for them slightly too?
Well, let's let them get in here first. I think they're going to come in my new side doorway, but I don't know for sure. You have the other one queued up too, Brian? Do you have the second one queued up? So you will have to do anything to it? Okay. Thank you. What is that she's distributing? Please rise.
All right.
I thought they took him to Paddock Lake for a swim. Okay, please be seated. It's my understanding you asked for the audio-video of the shooting, video from across the street. We're going to show you one, if that's not the one you're requesting, because there is continuation. So if this isn't what you're asking me to show you, please raise your hand and say, we want whatever you want. Okay? So, go ahead, Brian. Thank you. Was that the part you wanted? Or did you want the next part also?
That was my debate.
So, yeah, I see some yeses. Yeses, tell me. Tell me. We're good? Okay. Okay. Okay, thank you. Bye. Okay. Look, I gotta put my glasses on so I can see y'all. Okay. Yes. Okay, so ladies and gentlemen, there's a verdict, and we're gonna read that verdict when it gets in here, okay? There is to be absolutely no emotional response to the verdict, no matter what it is, by anybody in this room. It's important that that not happen. We know everybody is tense, but there is to be no response whatsoever, and if there is, they'll be ejected from the room. The court has to carry on some other duties that we have at that time, so I want no disturbance. The jury will leave. We will take care of some other business. Everyone else will stay in here. And then I will have the complaining witness victim family leave first. The Fuller family will stay here and have an opportunity to talk to Mr. Johnson and Ms. Scheidegger, okay? So that's how we'll do it, and I hope that you can all comply with that. Okay. Yep. How much help do you need getting stuff put away? You got it?
That's my body cables. Yeah,
All right.
Okay, please be seated. Has the jury reached a verdict?
yeah.
Would you give the verdicts to the bailiff, please? Notes are in there too, right? Okay, great, great. The verdicts read as follows. We, the jury, find the defendant guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 19th day of March, signed by the foreperson. Did the defendant commit the crime while possessing a dangerous weapon? The answer is yes, dated and signed also. As to count 2, we, the jury, find the defendant guilty of attempted first-degree intentional homicide as charged in count 2 of the information, dated today and signed by the foreperson. The question is, did the defendant commit the crime while possessing a dangerous weapon? The answer is yes, dated and signed by the foreperson. The verdict for count 3 is we, the jury, find the defendant guilty of armed burglary as charged in count 3 of the information. Is there a motion to poll the jury?
Yes.
Okay, I'm going to start in the back far corner, and you don't have to stand up. But I'm going to say to you, as to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? Next, as to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? Let's start on that end. Was this, and as to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? As to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? Ladies and gentlemen of the jury, I thank you for your service. You had a long, hard week of work, and I greatly appreciate it on behalf of all of the judges of Kenosha County. We are quite grateful for the wonderful citizen cooperation for supplying jurors for jury trials. It's an important constitutional right. So we're grateful to you. You're going to go back to the jury room. You're going to rip up your notes, and we'll see you, and thank you very much. We have a little bit of business to do. Mr. Gravely.
Your Honor, I would move for judgment upon the verdict, and also pursuant to the verdicts, we would move for a revocation of bond. Would ask for a date for sentencing.
Mr. Johnson?
We move for judgment notwithstanding the verdict.
Court is going to enter judgment on the verdict, subject to any post-conviction motions. The bond is revoked, and we will get a date for sentencing. Did you ask Heidi by any chance? Okay, we'll get to that.
Your Honor, while we are waiting to set a date for the sentencing, the court had previously ordered that Mr. Fuller not be able to have contact with certain family members. Now that the trial is concluded, we'd ask that that order be vacated so he'd be allowed to have contact with his family.
Counsel, I think that the other case still has a no contact order.
I'll lift it on this one at this time.
Sure.
However, if the other one continues it,
Yeah.
he's got to abide by that until something else happens.
I just want to be sure we're clear. I think the other one still has a no contact order, but, okay.
May 19th, 1 o'clock.
Say it again.
May 19th, 1 o'clock.
May 19th. May 19th at 1 o'clock, does that sound okay, or 1:15 probably? Wait a minute.
May 19th
Does Heidi say that's good? Oh, okay, well, I don't think that's right. I think I've got a post-conviction motion that day. Oh, really? I don't have delivery on that day? Which is supposed to go all day from the morning on. Do you see anything that says good? Yeah, it says I have it.
I'm sorry, the 19th, that one does not work.
That does not work?
No.
Can we consider that Friday, the 21st? I have a trial that starts that Monday, but then by Friday afternoon, I'd be available.
Okay, Friday, May 21st, does that work?
Is that all right?
Should we do it in the afternoon? Will we need more than an afternoon?
No, I think an afternoon would be fine, but if the court is ready to do it at, say, 1:30, so that
Okay, so,
I have an opportunity to finish my trial first.
okay, 1:30,
That's fine.
May 21st. Thank you very much. Thank you so much for all the work that everybody put in.
One more time, May 21st at 1:30, Ron?
Yes, sir. Okay. Now, I'm going to excuse, no, I'm not. I'm not.
I don't think so.
Okay, the Tudor family is nice to come. May I ask? Once your time starts up, you guys, okay.